Good morning. Good morning and welcome to the Committee on Professional Responsibility and Conduct. As you just heard, this meeting is being recorded. Angela, can you please take the roll?
Yes. Sarah Bonola,
Here.
Elizabeth Bradley, Raquel Brown, Cassidy Chivers,
Here.
Mary Grace Guzman, Brandon Krieger,
Here.
Joel Mark,
Here.
Eleanor Mercado,
Here.
William Munoz,
Here.
Daniel O'Reilly,
Here.
Vikita Poindexter,
Here.
Deepika Ravi,
Here.
and Hunter Starr. Thank you.
Thank you. Next on the agenda is the call for public comment. So State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool.
Okay. For those of you participating by Zoom, please use the raise hand function at this time if you'd like to give a public comment. If you're dialing in by the telephone, you can press the star key, then the number 9. So if you'd like to give a public comment, please use the raise hand function or the star 9 key at this time. I don't see any public comment requests.
All right. That's rare. Okay, so let's move on to approval of the minutes from the last meeting. May I have a motion? If there are no corrections or modifications.
I'll move. I move.
In a second.
I'll say.
Second.
Okay, taking the vote to approve the October minutes. Raquel Brown, Elizabeth Bradley, Cassidy Chivers,
Yes.
Mary Grace Guzman, Joel Mark,
Yes.
Eleanor Mercado, Willie Munoz,
I'll abstain.
Daniel O'Reilly,
Yes.
Vikita Poindexter,
Yes.
Deepika Ravi,
I'll also abstain.
Hunter Starr, and Brandon Krieger.
Yes.
So 5 yeses and 2 abstains.
All right. Thank you. So I'll start with the chair report. And the only thing to report is basically the main thing we've been working on for the past several months. Erica and I presented the AI guidelines to the Board of Trustees in I think it was the 16th meeting of November 16. And they were adopted without change. So I thank you all, staff members, everybody, for the many months of diligent work on this project. The reception has been interesting. It has gone from people thinking these are nice guidelines to people saying they're not objectionable, which I think is a pretty warm and hearty approval from a deeply curmudgeon-y ethics community that likes to complain. So I haven't seen anyone furious about these guidelines or saying that they're a bad idea yet. So I take that as a compliment of all of our work. We did stress to the Board of Trustees that this is a first step, that there are going to be, we expect many specific issues arising with respect to the use of AI in the practice of law that we may intend to address through, ethics articles or actual full opinions. And that in no way are we saying this is the final word on the topic. That was one of the concerns a couple members of the board had. So, and so I guess we'll turn to the staff report.
Well, Brandon, just going
Yes.
to add on that AI report, 2 things. The APRL was moderately accepting of this report.
I was shocked.
Yes.
I'm with you, Joel. Yes.
The second thing is I got a call from a reporter, one of the legal journals, I can't remember which one, and I never did talk to her in detail, but in the messages back and forth trying to get something scheduled, she did say that if adopted, this would have been the first in the country that she's aware of, that any bar has taken on AI. So I suppose that's a feather in our cap, if that's correct.
I think it's amazing that with the many months we took to produce this, we were the first.
I thought that, I'm sorry, that I think Florida has an opinion on AI. Did we talk about that?
You did- right. I think I didn't think it had been adopted as of the time ours was adopted.
Okay, okay.
I
can't
don't
remember.
know. I don't know, but you're absolutely right. Florida's got something in the works or very close.
I couldn't
Yeah,
remember
that-
if we talked about it yet.
That reporter did mention that Florida was working on it. That was the
Right.
last, but that was a couple of weeks old, so.
There
Right.
was an article today on it, by the way, in Law 360, I believe it was, from 2 attorneys at Debevoise that was pretty positive.
About our work or the Florida opinion?
Our work, it does
Oh.
reference the Florida opinion as well.
That's nice to hear. That's nice. Again, like I think anytime an ethics committee does something that doesn't produce a great deal of criticism, it's a rare and interesting occurrence.
I think it's unprecedented, actually.
I think
Well-
some folks really appreciated that it was in the vein of guidance and
Yes.
appreciated the, kind of fluid nature of the technology, but found it very helpful. At
Well,
least that
I
was-
mean, I think, and I'm very pleased that people are they're finding it helpful, and so we should probably really quickly talk about reporters calling because there's a policy on this, right? So if reporters call about COPRAC work, I think we're supposed to refer it to the State Bar comms office or something like that. I mean, we can of course speak individually, but generally, I think we're supposed to refer COPRAC related inquiries back to the bar. Is that right?
Yes, it is. So I can touch on that briefly.
Okay.
Depending on who you get a call from, they may already know, frankly, that they're supposed to be contacting the state bar. But you can certainly send them to me, and then I can direct them to our communications office. And then what will happen is they'll likely reach back out to you, our communications team, if they think that there should be a quote of some kind on this from a COPRAC member. They're helpful too, so they may even work with you to develop some good talking points. So that's a benefit of reaching out to the communications office. But yeah, if you're speaking, in a way that's identifying you as a member of COPRAC, then it's obviously just in your individual capacity that you're making such comments.
Erica, in my case, that's what the back and forth was about, that I was strictly going to be talking as an individual and that they should contact the state bar. So I hope
Gotcha.
that's okay.
Great. Brandon, I can give the staff report if you'd like at this time.
Yes, please. That'd be great.
Okay. I'll be very brief. So 2 quick things, one of which we will be talking about a lot more this afternoon, hopefully in kind of our little planning session that we're going to do with our new opinion topic requests. And also you see a new individual here, which is Brady Duar. So I'm going to do my quick spiel, and then I'm going to turn it over to Brady for a moment. He's from our Office of General Counsel. So first of all, I wanted to touch briefly on the Bagley-Keene open meeting requirements. So there are some changes going into effect January 1st that will hopefully actually not affect COPRAC too much here. So the differences, and I'm not going to go into it in too much detail, is that Bagley-Keene is distinguishing committees between advisory committees and non-advisory committees. Because COPRAC, all of COPRAC's work goes through the Board of Trustees, through the Regulation and Discipline Committee. COPRAC has been deemed to be a non-advisory committee, which allows for the committee to continue to meet in this forum. So on Zoom, you will not have to, be at an ADA accessible location and notice your address. One of the state bar offices, likely San Francisco, will need to be open to the public. So Angela and I will be attending the meetings there if you'd like to come and join us. But you can also, do so from the comfort of your office or home as well, going forward in January. So more information to come on that, including very specific details. But just wanted to give you a heads up in case you're on other committees that are subject to the Bagley-Keene open meeting requirements, because there are differing requirements for different types of committees. One other COPRAC related thing, like looking at it very holistically, is that COPRAC is subject to the Board of Trustees sub-entity review in 2024. So this is a review that happens every 5 years to look at the committees and evaluate them. Just wanted to flag that now. We'll be talking about that in a lot more detail this afternoon, but that's something that is on the horizon for COPRAC in 2024 as well. And so with that, I'll turn it to Brady, unless you have questions on the Bagley-Keene matter. And Brady is an Assistant General Counsel in the Office of General Counsel.
Hi, everybody. It's a pleasure to be here. My name is Brady Dewar. I am as Erica indicated, Assistant General Counsel in our Office of General Counsel. I've been here about 5.5 years. I do a real mix of things, some litigation, and I'm on our conflicts of interest and ethics team. And as you might have seen or surmised from the news, enhancing our conflict of interest policies, particularly at the Board of Trustees level, but across the organization, has been a big focus this year. And this year, as part of our annual review of the conflict of interest code for designated employees, which is a term of art and a bit of a misnomer because it's positions within the agency, whether compensated or not, has led us to make some additions or proposed additions and enhancements there. At the board meeting in November, the board approved for circulation for public comment the proposed amended code for next year. And this year, it adds, proposes to add both Jenny and COPRAC to the current 5 state bar sub-entities that are listed. I'll go through a little bit of what that means and let you know how you can provide public comment. It's a 28-page code, but it's double spaced, and it's actually pretty simple when you get into it. And I'll get started. Hopefully, be brief, and then open it up for questions. See if I can share my screen here. On. All right. So as part of our review, we realized that addition of COPRAC members to the conflict of interest code is required by applicable law and consistent with treatment of other sub-entities. Political Reform Act requires each state agency to adopt a conflict of interest code, which then has the force of law. And each code must contain specific enumeration of the positions within the agency that involve the making or participation in the making of decisions which may foreseeably have a material effect on any financial interest. So that's the standard. And we realized that because of the important work you guys do in proposing ethics rules and issuing opinions, if attorneys follow those opinions, that can impose costs on them. I think that the best example I could think of is a more restrictive view or interpretation of conflict of interest rules would lead certain attorneys to perhaps decline to take business that they otherwise would. So that can change their revenues. Then once it's decided that a position should be in the conflict of interest code, the code needs to list for each position the specific types of investments, business positions, interests in real property, and sources of income, which would be reportable. And luckily for you guys, assuming this code goes into effect, it'll be pretty minimal reporting because the only interest that is foreseeably affected by your decisions is the legal industry. So you just report your source of income in the legal industry. We don't need to worry about your investments in tech and bank accounts and any other industry but the legal industry. 5 state bar sub-entities have been listed on the State Bar's conflict of interest code for many years. And this year, we realized that under this standard, COPRAC and Jenny, which can affect people's employment, should also be added to comply with those provisions. So I just want to go through a little bit of what this would look like and what this would entail for you guys should it again go into effect. I'll mention this, but the board will be considering adopting it at its January meeting. So the first and probably primary effect for all of you is that you would be required now to file what's called a Form 700 or Statement of Economic Interests. And what that does is you file it when you assume office, and you'd be considered to assume office when the code is adopted, since you hadn't been listed before. But you disclose your financial interests, and that's your investments, your real estate, your sources of income, and gifts only that come from these specific categories. And the categories that you would fall into is category 2, which is essentially the legal industry. It's stated a little bit more detailed than that, as you can see. Sources that are subject to the regulatory permit or licensing authority of the State Bar of California, or have an application for a license, permit, or other certification pending before the State Bar of California, including but not limited to California attorneys and law firms, applicants to become licensed, California lawyer referral services, and California legal aid providers. There's a second category, which won't come up very much for you guys, I don't think ever at all. And it's sort of a catch-all category that says, if during the year a decision came before you and you were forced to recuse yourself from it because that decision was going to have an impact on your financial interests, you'd need to list that as well. But because all of your decisions are only affecting the legal industry, you'd be disclosing those under category 2. So, but again, category 13 is sort of a catch-all that all of the positions in the code have, just in case, again, there's some decision that somebody's making that's affecting an interest that they weren't otherwise disclosing. The disclosure form, it's called the Form 700. You would get instructions. For most people, it's going to be 1 or 2 pages, the first page, and then if you have an income to disclose, you add a schedule for income. But I just wanted to make clear at the outset, the disclosure is not of specific dollar amounts, but rather ranges. So it's not, like disclosing your tax returns or anything. For instance, if you work for a law firm and need to disclose that, you just name the law firm and then you name a range, and the ranges for income are 500 to 1,000, 1,000 to 10,000, 10,000 to 100,000, or over $100,000. And you just click one of those, and that would be it for the disclosure. Once you're in, once a financial interest falls within category 2, in other words, the legal industry, there are several types of financial interest that would be reportable. So first is investments in real property. If you had an investment in a law firm, say, valued at $2,000 or more, and it was doing business in California, that would be a reportable investment. Income, if you have income from the legal industry of $500 or more, that would be a reportable interest. Gifts are a little different. Gifts are reportable if they total $50 or more, but that's subject to a wide range of exceptions, including gifts from close family members, reciprocal exchanges of gifts of similar value on birthdays and holidays, gifts from someone with whom you have an existing personal or financial relationship, personal or business relationship, as long as there's no evidence that that gift was intended to influence your co-prac decisions. So it's really just getting at, sort of a gift from the legal industry from somebody that has nothing to do with you other than, oh, hey, let's give a gift to everybody who's on co-prac. And finally, you disclose business positions in the legal industry, and that could be compensated or uncompensated if you were a director or employee, trustee of say you were a member of the board of trustees of legal aid, you would disclose that as a business position. There are also, in addition to the disclosure requirements, a few prohibitions that come along with being named in the code. First, and I believe this probably overlaps with your existing conflict of interest disqualification provisions, but you would need to disqualify yourselves from participation in a decision having a reasonably foreseeable material effect, distinguishable from its effect on the public generally, on yourself, your spouse or child, or one of those financial interests that you needed to disclose. And what's key here is that you only need to disqualify yourself if one of your decisions would have an effect distinguishable from the effect on the public generally. And the way that's defined is it means distinguishable from the effect on the public generally being the legal industry, lawyers. So you're not going to have to disclose, you're not going to disqualify yourself from making a decision on ethics unless it affected you or your employer in some very particular way different than how it would affect all law firms and all lawyers. You cannot accept honoraria for speeches, articles, or event attendance from a source that's reportable on your Form 700. But again, there's a lot of exceptions to that, including for income earned in connection with customary services in your bona fide business, trade, or profession. So you're a lawyer, you're a law professor, it's customary for you to go and do this. You can keep doing that. It's just, again, aiming at getting, people paying you for something they wouldn't otherwise, just because you're a member of COPRAC. On gifts, there's a prohibition on accepting more than $590 in a calendar year from a reportable source. Again, that's subject to all of those same exceptions. If you have an existing relationship, it's your current employer, your former employer, anyone of that nature, and again, reciprocal exchanges, holiday gifts, all of those are excluded. It's really just getting at, barring you from accepting large gifts that are intended to influence your decision making. And finally, I don't think this will have any effect on anyone, but you may not receive personal loans from an officer, employee, trustee, consultant, or contractor of the state bar, which is subject to exceptions, including for commercial loans and credit card transactions, so long as those loans are made in the regular course of business. The next steps are that the board item and the exact proposed conflict code are up on our public comment page. I've put it there. It's actually just much easier to Google State Bar of California public comment. It'll take you right there. Public comment is open until January 4th. The Board of Trustees will consider adoption of the proposed code at its January 18th and 19th meeting. And if it is adopted, because you would be considered to assume office, this is the first time that COPRAC members have been named in the code within 30 days. So around mid to late February, you need to file a Form 700. We'll provide instructions. OGC will be available to assist. And the Fair Political Practices Commission has some really great FAQs about filling out the form at that website. Again, I always just Google FPPC Form 700 and I get right there. One more note about Form 700 filing. After the assuming office, you'd file an annual form as long as you were a member of COPRAC. That's due on April 1st of each year, and it looks at your financial interests for the prior year. So you would not need to file in 2024. You would in 2025 if you were still a member of COPRAC. Instructions will be provided, and then when you leave COPRAC, you would file they call a leaving office statement within 30 or 60 days. I'm not remembering off the top of my head of leaving, but again, you'd be provided the instructions at that time. So with that, I'm open to any questions.
Are they going to increase our compensation at COPRAC for this? Thank you very much for this information. I appreciate it.
Thanks a lot. You guys have a great meeting, and I should have put my email address up there, but it's brady.doer@calbar.ca.gov, and you can always reach me through Erica also.
Thank you.
Thank you, everyone.
Well, that's exciting. Everybody gets to look forward to that now. So with that said, and unless anyone wants to comment, seems like an exciting additional step to volunteer. So I think we should turn to our discussion of the succession planning draft opinion. And before we begin, can somebody remind me where this stands in the public comment cycle? I know this one's been around for a while.
I can do that unless Dan would like to. I believe it's been through 2 rounds of public comment at this point.
Okay.
And so the question would become, depending on the edits and depending on the committee's action today, if it needs to go through an additional round of public comment, if the committee wants to move forward with it.
Right, and we have, so we have three opinions for discussion today. And unlike the past many meetings where we are sort of racing to hit a deadline on the AI project, we have time to dig in and actually do some wordsmithing and try to get stuff, not kick the can down the road, and actually see what we can button up today. Because people have been putting in a lot of hard work on these opinions, and I'm glad that today we have the opportunity to give them the attention that we really want to. So Dan is gracious enough that he's going to lead us in a discussion of this draft. And I will turn the floor over to Dan.
Okay, thanks. The most recent one, excuse me, includes Erica's notes and comments, I think, and mine as well, or at least just the revisions from the most recent red line. As Erica mentioned, we had public comments most recently that we talked about in our September meeting, and we were previewed. They weren't super involved, and Erica and staff went through and made those changes, and then several of us, or at least I, reviewed and made a couple of additional notes and comments. A couple things stand out as things that I think the committee should think through and just sort of discuss. And I'll start with one of the first paragraphs. The CLA made a comment that is applicable throughout the opinion in various places. And it basically suggests that the rules require succession planning, or it requires lawyers who have active caseloads have an ethical obligation to engage in succession planning. And my personal opinion is, my professional opinion is that that's a true statement, because when I advise clients, I look at the rules that are discussed here in this opinion, and I say, it's difficult for me to imagine a way that you could comply with these rules without a succession plan. I mean, including on a most basic level, avoiding foreseeable prejudice to your clients. And on the other hand, the issue is the rules don't say that. And they, the ABA model rules do have a comment 5 to rule 1.5 that says that lawyers should, doesn't say must, engage in these types of considerations. So that would be, I think, issue 1 for the committee to sort of think through. It somewhat implicates topics we discussed before, which are how best to say something that we probably practically know to be true, and yet isn't making new law or coming up with some affirmative statement in a new way that isn't firmly anchored in the text of the rules. Because California doesn't have a rule that says you have to do this, and us saying that you do have to do this is a synthesis of other rules, and to what extent is that appropriate? So that's a place to start if anybody has a thought on that.
So I will jump in, because I was just sort of tracking the highlighted comments, that have been going on in these drafts. I think it's appropriate. I think maybe I think it's appropriate for us to engage in that sort of synthesis, because our utility goes beyond just explaining what's in the express language of a rule to what it means or intends. And if it is the conclusion of this committee, and I'm leaning that way, that compliance with the express rules necessarily requires, this sort of planning, I think it's appropriate for us to so state, if that is the opinion of the committee. I think if we take the view that we only get to sort of reiterate what is expressly written in a rule, we are limiting the utility of what we can offer as an ethics committee. That's my 2 cents.
I mean, an alternative which often appears, and I know this opinion has been polished and fully baked, and so what they've done in previous iterations, I think, is to go up to the line of saying you must, to saying should consider or may have an obligation, and that is another viable alternative. But then, I mean, my view is, to Brandon's point, why not say it if we think it's true? I don't think we're breaking new ground too much. On the other hand, we don't need to overstep on that particular issue if everybody thinks that we should just say that it's something to consider. There's liable to be significant public reaction to that because, like many of the things we do, it implicates duties that people either haven't focused on or don't necessarily want to take on.
I just have a question. Does anybody know, or has anybody looked at when we adopted the model rules, the numbering and all that, was comment 5 addressed or looked at for when the diligence rule? Was anybody here? Anybody here that was on the committee back then that recalls that? I'm just, there's, when we look at revising rules and comments, we're very focused, and so I'm sure it was discussed, right? I mean,
Yeah, there must be rules revision history, right?
yeah.
I can, while you guys are continuing this discussion, I can try and look that up real quick, and I'll have an answer to you in just a moment.
Just so everybody has a sense of it while Erica does that, the comment 5 to the model rule 1.3 says, in part, the duty of diligence may require that each sole practitioner prepare a plan in conformity with applicable rules that designates another competent lawyer to review client files, etc. Essentially saying it doesn't go so far as to say you must, or even that you should. It says the rules may require you to do it. So even that, which is not present in the California rules, is relatively weak.
Yeah, well, so let's just, if we were to engage in a little brainstorming, what's a scenario in which you don't have such a duty? What would it be? Is it because you have a firm and you've got enough other humans there to step in already without talking about it? It's just like tacitly covered? Because I can't see a scenario where you are engaging in legal work for clients and you haven't at least planned for what would happen if you're incapacitated. And that is competent. That's just my thinking on it.
Yeah, and Dan and I were talking about this earlier. This is, the purpose of our rules, the fundamental purpose of our rules is to protect clients, right? And this is becoming, a lawyer's either gradual or sudden death or incompetency is becoming a big exposure for, to client. It directly relates to client protection. And that's one of the one of the scenarios where harm is greatest, so I think, but on the other hand, imposing a duty on one lawyer who may be, or a firm, may be easier than, say, a solo practitioner who doesn't have colleagues to turn to, that may be more difficult, but also more needed in that scenario.
Exactly. I sort of think on the continuum where if you are in a firm that's integrated and people know about the existence of your matters and you get hit by a bus, that's awful, but hopefully the clients aren't going to suffer, unnecessary prejudice.
Yeah.
And it's the sole practitioner where it's really important. Maybe we need a rule on it. I don't know. I think, I think that at the very least, it can be a must, or requirement, but that we should set forth minimum requirements, so that it's not like this should not be a huge burden on the solo to accomplish in order to protect clients. And it shouldn't be an impediment to practicing law, right,
to having a thriving practice.
Yeah, nobody wants to burden people and take them away from the actual productive work they're doing unnecessarily. But it sure does seem important, and perhaps most important with sole practitioners.
Right. Like what Dan and I were talking about, just make sure somebody knows where the passwords are. You know, like there's certain steps that need to be taken that are common sense and not burdensome.
Well, that's one thing to remember, which I think is important, which is that we're not talking about somebody who's going to come in and buy your practice in a complex transaction. We're talking about somebody who could keep the lights on for clients on an interim or permanent basis, but even on day one, when something happens, to go in there and make an assessment in some way. And it doesn't require you to have, as a solo, it doesn't require you to have complex plans. It requires you to have someone somewhere and somebody else who knows who that person is, so that you could contact them and come in and find your passwords, figure out what deadlines exist, if any, and put together a plan to handle things like that, including just notifying the courts or whatever, so that you don't have
Right.
a mess.
And
that's a pretty low bar.
Right. I think the opinion's pretty clear too, that there's a range of things you can do. You can have a super robust, totally planned out, wonderful, bespoke plan in place, and then, you know, hope to never need it. But like what you just said, Dan, at a minimum, you need to have not siloed off people who are vulnerable, who are your clients, so that if something bad happens to you, nobody can even reach them to communicate and help, you know?
Yeah, so that brings to mind what you talked about earlier, which is, you know, comment 5 from the model rules singles out sole practitioners and basically says they may have a duty. But I think it could, I mean, this paragraph that we're looking at right here in the digest and the similar language below is true. And it could be modified or augmented just by saying a sole practitioner likely has a duty to do these things, you know, because if you're not in practice with other people, it is different from succession planning perspective.
Yeah. And maybe a nod to how integrated a firm is too, because, you know, we all know about like small partnerships where one attorney handles real estate matters and the other attorney is the litigator and they never know what's going on. Maybe it's just every attorney has an obligation to assess whether their clients will be contacted, knowable, communicated with in their incapacitation. And if that's satisfied just by the nature of your firm already existing, great. And if it's not, you have to take some steps.
I think that's a good formulation of it. I would be in favor of saying that. It's not like it's ground shaking to say every attorney has an obligation to assess, but I think that captures it, because a lot of people don't even want that obligation.
Right.
Can I add that?
I'm going to apologize. I'm going to call on Joel and again, for the second meeting in a row, commit myself to look for these little yellow hands that I'm sorry, Joel. Yes.
Wow. Okay. You know, it's as my experience 10 years ago when my law firm in Ventura went out of business. It's not an obligation limited to just a sole practitioner. We had a firm that went from 18 partners down to 8 partners, down to 6 partners, down to assigning our assets for benefit of creditors, and because we couldn't afford to lease any longer. And the big problem we had was this was the longest continuously operating firm in Ventura County going back to 1939. And the last time anybody cleaned out the files or dealt with file destruction and passing on files to clients who might need them was back in the 1960s. We found a COPRAC opinion which said that even former partners have a continuing obligation with regard to dealing with that stuff. But out of the potential 18 partners who had been there, there were 3 of us who locked ourselves in a room for a week and started to try and sort that out. And had we had an ongoing succession planning kind of viewpoint of what do we do with client files and destruction and that kind of stuff, we could have spared that. And there were some clients who I continued to get calls for about, as a former managing partner, continued to get calls for maybe 5 or 6 years afterwards, you know where my file is, how can I get it, who might be know anything about my former matter. Typically in an estate or real estate situation. And there's also an opinion on the estate obligation, estate attorney's obligations to personally deal with the estate planning documentation for clients. So I can't recall if that worked its way into this draft, and I confess I didn't read it for this meeting, but it's just not limited to sole practitioners.
I think that's true. I'm sorry, I didn't raise my hand, but I think the question from this opinion's perspective will be like how to properly capture that it is actually more likely, it certainly will come up in a sole practitioner context, but there are many instances where in firms that have unrelated practices among partners and things like that, or like you say, Joel, that have a long history of practice that not everybody even knows about, that implicates a lot of other duties. You have to think through this before the day of.
I have my hand up. Now I'm like, are we gonna wait until we get called?
Cassidy, I apologize. I called on you, but I muted myself. This is just
Oh.
terrible. It's
It's amateur hour over here.
yeah, I'm so sorry.
So one kind of angle I was thinking about is, okay, so what happened, like, what is the standard if there is a complaint for violation of these rules for failure to succession plan? Is it, you know, the sufficiency of the plan itself, or is it going to be you didn't even assess, like what Brandon was saying, you know, there's no succession plan at all is the standard. So as long, in other words, there would be no violation of the rules as long as they've made efforts to have a succession plan.
Well,
I mean,
that's
how
an
to,
interesting point. I would not say that this creates that assessing it or doing it even creates a safe harbor with regard to any rule.
okay, right, because you got to look at
Yeah.
each role and how, you know, what was violated and how, right? So
Yeah, but we're talking like a prophylactic like exercise is to first assess it. Coming up with a plan that actually would work or could work is another good step. But that doesn't mean that you're going to be somehow insulated from any kind of responsibility for all the rules in and of themselves.
So
right, but so then that gets to, you know, okay, well then what is the violation then? At what point are you, you know, violating the
Violation is
rule
of
for-
the rules. You're dead. You
Oh.
didn't communicate with me on the day after, you know?
Well,
Yeah.
that's why it's under the, I think, if anywhere, under the duty of competency, because in most cases where you are having to need a succession plan, you're out of business anyway. So what are they going to do to you?
Well, that is
Yeah,
that
they're
true?
retired.
Is there
So-
any scenarios where you could be disciplined for failure to have I mean, the law firm management, you know, could, you know, there could be partners who are existing who didn't take care of a retiring partner's succession plan.
I think a lack of a succession plan in some circumstances could be the basis for its own violation. But it wouldn't be, if you do one, it wouldn't be a safe harbor for
Everything.
some
Yeah.
other allegation. Yeah.
Well, it would tend to support you know, it would weigh against it, I guess.
Sure.
But, yeah.
Erica?
Yeah.
So I want to pick up on what Joel just said for a second and just talk about like big picture role of COPRAC, I think to some extent, because we are looking at this. I mean, you're correct in what we're saying here is if you don't have a succession plan, you may be violating one of these rules and ergo subject to discipline for not having a succession plan. I mean, that's like the logical conclusion. But just because that's the case, to Joel's point, you know, typically you only realize there's no succession plan in place if there's, you know, an unexpected death of somebody or an unplanned illness of some kind where they're not going to be practicing law anyway. So there's limited accountability to some extent through the discipline system. That being said, you know, COPRAC does develop guidance in a manner that will further the most protection of the public and the, I know we spent a lot of time in the AI conversations talking about best practices and how we try and avoid that to some extent. But that is to some extent also what COPRAC opinions do, right? is offer up better ways to practice law. And so there's a lot of efforts that have to occur if an attorney does not have a succession plan, including assumption of a practice by a court, which is often something that's transferred to the state bar or to someone else. And so, and in that time frame, there's a lot of harm that can happen to a client. And so, yes, there may be like difficulties in holding individual licensees accountable if we do say in this opinion that a succession plan is required, or the assessment of whether to have a succession plan is required. But that being said, I think that statement will still have a significantly beneficial impact for clients and others who may have to pick up the mess, including, a lot of family members. The ethics hotline gets a ton of calls from family members of unexpectedly deceased attorneys, frankly, with what do I do? And this would really help with that.
Well, there is the guidance on that. Is it still up on the state bar about, is it called succession planning?
Yeah, it's part of the senior lawyer resources page, and there's like a checklist. Cassie, that's kind of funny because that would be my follow-up after this conversation is what guidance can this committee or someone at the state bar offer as to how to better develop a succession plan as well. I know there's some guidance in this document, but that may be a next step here. If we say a succession plan is required, okay, how do you actually do it?
Yeah. Yeah, because that's what I've used in the past when I've advised on this. But sometimes I go back and like the senior lawyers page isn't there or something. Yeah, so I wasn't quite sure if it was still current. Yeah.
So
from a drafting perspective, go ahead.
Oh no, I was just going to say, I think if we phrase it in the idea that every attorney has a duty to assess, that there's some plan to take care of their clients if they were incapacitated. I think we can remove. There's a couple instances in here, and I need to find them, where we're kind of talking about the simple logic, the fact that there's a baby boomer generation that's still practicing law, that's getting older, and there's a couple references to, older practitioners have to really think about this. And I think we can kind of remove a lot of that because it'll be less offensive to certain members of the bar if we're just saying everybody has to think this through. You can be, a young person with no foreseeable incapacitation, but you still need a plan because terrible things, accidents, whatever, still happen. It might not hit I'm expecting to hit a nerve with a lot of people on this that I'd like to minimize and still have the opinion be just as effective. Does that make sense?
It does to me. When you go to the next level where you say that every lawyer has a duty to assess, then it does relate to all kinds of things that could happen to any one of us, not just a specific subpopulation.
Maybe solo practitioners won't feel so singled out if we're talking about, once you make your assessment, you can say, oh, the way my firm works, we're just fine, right? Great. Yep. Hopefully you're right. But it's not singling out the solos as much either. Joel?
Yeah, Dan, I got a question. After 2 rounds of public comment, has anybody pointed out some reason or rule or whatever why we couldn't have this kind of an opinion connected to the duty of competence and all the other rules which do sort of implicate or show us why we should have one of these things?
I think they fall, and Erica, you can correct me if I'm wrong, but I think they fall into sort of 2 categories. One is, and there weren't a ton of public comments in the last round. They were pretty minimal, but there were some public comments from sole practitioners who were like, this is just another onerous burden of things that we have to do and try to figure out, and would impose costs on us that are not imposed on other firms, et cetera, along that line. And then I think, the other hesitation I think that we had in drafting, or at least that I did, which is it isn't strictly in the rule. And so where to draw that synthesis line is what, what we brought up, obviously.
So Dan, what do you think would be a good approach to get the opinion of the committee here? Like, do you want like a straw vote on whether this should be a rule or a suggestion, or what do you or should we go through your changes first?
No, I think we could do a quick vote on that. I mean, this formulation, which is basically like the first sentence here, right? If that were revised, it could carry through in 4 or 5 other places that would capture it if that's what everybody agreed to do. Meaning, this first sentence now doesn't say this, but it would be revised to say every lawyer has an obligation to assess. And then the changes that would carry through would be restating that in 3 or 4 places where that appears and taking out the population specific references like older lawyers or sole practitioners or whatever, because it's, as you say, it simplifies that. After that, there are only a couple other items that I think are significant to sort of talk about, and it could be pretty quick.
Okay.
So if we came up with the revision of that first sentence, then we could carry that through and take out the other specific references to populations and probably be ready just with the other options.
Okay. Dan, do you feel like drafting on the fly here?
Maybe we should do a straw poll to see if everybody agrees, because
Okay.
I'm just talking and I don't know if people
Sure.
really agree with this.
Sorry, Erica. Yes.
Oh, I'll just add this change would certainly have to go back out for public comment. So 2 things here. One, I was mistaken. I think it's only been out for public comment once, so apologies on that. But 2, because it would have to go out for public comment too, I don't think, I want to just point out the committee maybe doesn't have to have it be perfect and could perhaps direct the working group and staff to make those final tweaks with direction before it is issued for public comment, just to move this forward.
Great.
That process worked very well, by the way, with the amazing staff at the State Bar, because we did this last time and it worked very well. So I propose that we do that again instead of drafting on the fly.
Okay.
Just sort of pointing in the right direction, and the staff can expertly execute, and then we'll look at it again.
All right. So should we do the straw poll on the revision that we're talking about here, that every attorney has a duty to assess, and then where appropriate to engage in succession, or where required to engage in that?
Straw poll.
Straw poll.
Is it duty to assess or duty to engage in succession planning?
I think it's
Which is-
sort of twofold: the duty to assess and where appropriate to engage in, or where required to engage in, right? Because there are plenty of firms where just the structure of the firm is a de facto protection for attorneys, right?
Yeah,
But you
Okay.
got to assess it, because your firm might not fit, or your practice area might not fit that.
right. Yeah. Okay, I got it.
Okay. All right. So do we need a straw poll, or should we just put our little digital hand? Oh, Topeka. Yes.
Wait, just to make sure I understand the scope of the proposal, would it be that the opinion is revised to say that every lawyer has this duty to assess, but also to clarify that what that assessment looks like would vary depending on the nature of the lawyer's practice?
Yes.
Okay.
I think so. And then where it's appropriate, where the assessment shows that there's not enough protection for the clients, then you better engage in some succession planning. Okay. How do we do the straw poll here?
I think we
I
should use the
can-
raised hands.
Okay. Anyone who's on board, raise your hand.
Wait, on the thing? Okay.
Yeah.
Oh, on the thing.
Looks like people are on board. Okay. Okay. So I think we should be pretty comfortable with that.
My hand now.
All right.
There's one other related point to this that goes right into and if we're taking out population specific references, which I think mostly we can do, there's one subcategory that comes to mind of people who are impaired but by the nature of the impairment don't know they're impaired, which of course relates to sort of dimension, those types of related things. This is a note that we put in on page 5. Does it make sense to specifically identify this, because this is a unique problem? It's not I got hit by a bus, I can't do anything the next day. It raises multiple other potential questions, like if I got a dementia diagnosis, don't I have a duty to disclose that to my clients? I think most people would agree with that academically, but never do it. And then
Yeah.
I think, one of the sort of characteristics of that type of a diagnosis is that you don't know it's happening and you don't want to admit it. And it's that aspect of it. It's one of the traits of the diagnosis. So if we're gonna reference a particular situation, not necessarily a population, but a situation that just to flag it for people, that would be the one that I would suggest.
Well, would it be terrible if we did have at least one part of this which kind of outlines all these various situations where a succession plan really would help protect clients, including death, retirement, accidents, creeping senility, those kinds of things. Just say, for all these reasons, that's why it's an ongoing duty.
Well, sorry, I should raise my hand, but one of my concerns is that with respect to this key issue, right? Sort of dementia, the succession plan is not going to help until the very end. And, there's going to be a lot of damage during the time period that the practitioner doesn't recognize their impairment, during the time that they are in denial or quiet about, so this is sort of like the emergency fire alarm or something. Until it gets pulled, it doesn't help. And so maybe, I don't know, we can reference that issue, but
one option would be to make that sort of a statement about the duty to communicate, meaning you have that is really early days, right? And nobody knows where that line is, but it's earlier than the very end.
Yeah.
That's for sure.
Well, but isn't it do we talk about, it's like if a lawyer gets in a car accident or has to be hospitalized for a couple of months, or, has a temporary illness that does impact their ability to practice, does that, you certainly would have a duty to communicate, but that's an emergency situation. I'm just, are we, and this a little bit off topic of what you guys were talking about, but is that part of this as well? You should be prepared for, you should have this in place so that if there is a sudden illness, somebody could jump in temporarily.
Yeah, but that is part of it. Yeah.
Yeah. So I'm just realizing, because I was just going back through our old opinion list. We have colleague with an impairment, and then we have succession planning, but we have this gap that a solo practitioner experiencing dementia is going to fall into. And is that its own opinion that maybe we allude to here, or is it a new issue? Because I'm not sure it gets addressed with succession planning. It's much more affirmative than that in terms of like self-awareness and examination and that thing.
Yeah.
Well,
I think it's a deeper probably topic, but should be referenced here. At least some of the different people that I've heard present on that topic have suggested that you're only going to ever address the problem with some kind of an objective test, like DMV type assessment above a certain level. And that's different world than where we are now.
Joel?
I'm not sure in this opinion, we're going to be able to discuss all the possible triggers, but of each situation, but to list each situation as a possibility of just why it makes good sense for you to have a succession plan, as well as a requirement to comply with all of these rules of competence and duty of loyalty and those sorts of things. And I wouldn't dwell on how you go about rooting out the trigger point in time where each one comes into play. But eventually, every one of these things are going to come into play, and this is why you have to have a
Yeah, so the
Yeah.
opinion does have a lot of specific examples, Joel, of things that would be reasons why it has to happen in different categories. But this comes up as a separate issue because the nature of it means you individually won't know it's happening. So if you're going to do a proper succession plan for dementia, it should be having a colleague who can also assess that or raise the issue if they notice something that looks like it falls outside of it.
Well, I don't think the legal community is going to like the idea of the state bar having like a DMV exam at a certain age, but it's
That's for
obviously
sure.
not a terrible idea, but it's not going to fly.
The DMV can't even really do it, in
No.
all honesty.
Yeah.
So,
Um,
okay.
Look,
Well,
it
whether
sounds
that
like,
kind of a reference should be included, it could be more generic by saying like, they might be incapacity that is something where the nature of it means the person suffering from it doesn't know it's happening, and that presents, unique circumstance, but it still should be contemplated.
yeah, that's a tough one, but yes, like it shouldn't go unstated. And we can say that, that is beyond exactly what that might entail is beyond the scope of this opinion, but we flag it because conscientious practitioners, want to protect their clients.
Yeah.
Nikita?
I'm not
So can you say upon, or maybe adding something to the effect of upon diagnosed with?
That I don't know personally, but my sense is that comes pretty late in the process. Like a diagnosis of something like that actually requires quite a bit of potentially damaging behavior before you even get a medical diagnosis.
Right.
well.
Yeah.
Not necessarily.
No, it's true. You might get an early diagnosis.
You
but
might get an early one, yeah.
Well, but the point is, whether there's a diagnosis or not, this is why you should have a succession plan in place against all these emergencies. And I'm not really excited about including in this opinion some obligation to seek out a practice buddy to constantly look at you and decide if you're competent to practice or not.
Yeah.
So I don't feel comfortable about attacking the specific trigger point at which creeping dementia now has to be more specifically addressed than just the obligation to everybody have a succession plan.
Well, it's also deeply unreasonable to suggest that attorneys have friends that look out for them, as we all know that's unrealistic.
For free.
Right. That's not going to happen. No, that's a good point, Joel. I think as we talk about it, this diminished capacity without, it's not your colleagues' diminished capacity, but your own issues. It's a really interesting topic that maybe we should, we don't need to go down that road here, but maybe we should consider whether we have anything useful to offer on that point elsewhere. Because it strikes me as very important, and it's not going to get less important in the next few years. But otherwise, look, I think this is a really excellent draft. And, Dan, do you think you have enough information and feedback from the committee to work with staff and make these sorts of changes?
I think we can take this and track the changes through to another form that can go out. Yeah, I do. Erica, do you have a thought on that?
No, I think that could work. I'll just somewhat related to what we were just talking about as it relates to the diminished capacity of an attorney. I'll just note that our lawyer assistance program does MCLE presentations and very delicately relies on the diminished capacity opinion to suggest how another attorney can help an attorney who's suffering from diminished capacity for whatever reason, including, substance use or mental health issues. But also, delicately kind of threads the needle to say, these are good things for you to look at reflectively as well, and to engage in a little bit of self-reflection. So I think that that is truly a gap that exists, and could be helpful for attorneys. And it doesn't have to just be related to cognitive decline, but could also be a broader opinion.
That's maybe a resource we could reference.
Yeah.
Yeah, that's smart. That's smart.
Well, that's part of the succession plan, right? I mean, you know, if you know, early days of perhaps feeling like you have diminished capacity is to reach out to that resource, you know, make sure you know what the resources are, you know.
Does it include an unwillingness to practice law? That's a separate conversation.
Yeah.
The only other thing, Dan, I don't know if you want to spend some time talking about, it may be moot based on this conversation, but the communication obligation that was addressed on page 8, I think, 7 and 8.
Yeah, I do think it's worth talking through that because it is a specific extension to another rule. This is on page 8, and Erica had a note that references CLA's public comment suggesting that the duty to communicate is implicated, which I agree with. Sorry, the confidentiality. Is that what you're talking about, Erica? On page 8?
Let me see. I believe so. So I think what was missing, and I apologize if I don't recollect this completely, but if you look at the bottom of page 7, it added in a few things, including calling out each of the rules that were potentially violated under scenario 1. And that's at the end of the first paragraph of the analysis of factual scenarios under scenario 1. So I think, I'm just trying to see where you are in the document, and a little higher. There you go. Yeah, perfect. Okay, so right there, we added the actual references to the rules. I believe that was at CLA's request, as Dan mentioned. Similarly, in the paragraph right below that, it was they suggested it explicitly state that it would violate the lawyer's communication obligations to their client by failing to notify them. I don't think that's super controversial, hopefully, if they're out for a long period of time.
Well, so what is the timing on this note? Is this like an advance notice? Like I have to tell all my clients like, hey, if something terrible happens to me, so-and-so is going to be stepping in? Or is this when something terrible happens to me, the notice goes out?
To me, it's when something happens, this person notifies my clients that I'm dead or something.
That seems 100% reasonable. 100%.
Yeah. I don't think that it's reasonable to have everybody say, the following things could happen to me, like today, right?
Right.
Or very useful because it's like an advanced waiver of a conflict. It's not worth a ton.
Yeah, agreed. Okay.
That's my interpretation of it.
I just want to make sure that's what we were talking about with the communication duty. I agree that it does implicate communication, and certainly you shouldn't have some other lawyer who's a stranger to your client stepping in without some sort of communication,
Yeah.
On page 9, I think this is page 9, I apologize. This is actually what I think we're getting at here is like advance notice of a specific lawyer being named in your succession plan, and advanced consent to share information, client information with that individual lawyer. So as you can see, hopefully on your screen where it says CLA suggests that there should be information about whether lawyer C provides notice to their clients about another lawyer's need to access the client files to perform the functions set forth in the succession plan. And so I do think that the communication, we should talk about whether a communication obligation exists that indicates, I do have a succession plan and it would allow for X, Y, and Z to occur, or if that's not necessary under 1.4.
Yeah, just as a context, my initial view is that it's too much. I feel like that particular concern is mitigated by the lawyer who's doing it has those independent obligations of confidentiality conflicts, duty to avoid different things, and they would be immediately assessing that when they went in. Because then you get into a bunch of different pretty onerous situations where I've got to tell every client, this is the person who's going to be succeeding me. And then what if clients, object, or they're, who knows what, you're dancing on the head of a pin, in my opinion.
I totally agree. I think it's far-fetched, like a conflict that's that remote isn't a real conflict. I just don't think it's necessary in the advanced sense. I think when it's implicated, there's going to be communication. If the client says, oh, I hate this person, I don't want that, then they're going to go to another person. I think it's, and since every human is mortal, every human has to identify it and put it in a fee agreement. And what if that person changes, or it's going to be someone else? And I'm not sure. I don't think it really makes sense. Joel.
There's a difference between the attorney who can take over versus the attorney who can unlock the door and let whoever you choose to take over in to get the stuff.
Yeah, it doesn't have to be the same person. And it's not the same function. I agree with that. Dan, are there any other items you want to talk about with the committee now, or are we, I think you've got a great draft here. And yeah.
The only other thing I'll note is that there was one public comment related to sections of the probate code that the commenter felt could be solutions to these things. But of course, by the time you get into probate, you're way down a really, really, really messy road with a lot of potential harm, right?
Right. So I have one question, and maybe this is better for staff with the historic knowledge, but I don't recall seeing opinions citing to the Rudder practice guide before. Is that routine, or have I just not dialed in on that? Because there's some citations to the Rudder guide here. I just didn't know if we did that or went to the sources beneath the Rudder guide usually.
Typically, I believe it's the sources below the Rudder guide, but I'm not, maybe I'm searching the wrong section. I'm not seeing a Rudder. Can you point to it for me, Brandon, where it is in this one?
I've got one at line 306. And
Sometimes the Rudder guide does not have citations, and they provide guidance, that's just sort of a consensus of
yes,
what Mark Tuft believes, I'm assuming. But yeah.
Oh, there it is. Okay, it's not listed as the Rudder guide, so my Control F
oh,
function
I'm sorry.
is not working very well. No problem at all. Okay.
Formation of relationship. I have it right next to me. I can see if there's a site under there.
I'm guessing it's a string site of all of the formation cases and opinions that talk about how formation of attorney-client relationship occurs. But
it's formation. Wait, this isn't even California. This is, chapter 3B. Where's 3B? There's
but
no
I
cheat 3B.
Point
I think it's
taken,
after
Brandon.
3A.
And we can explore whether to more clearly provide the case authority when there has been a formation of an attorney-client relationship.
Joel, did you have another comment? I just didn't know if your hand was still up from before, or if it was
Well, no, but I do now.
Okay, perfect.
I just recall on our MFA advisories, when we did that, we often put in the phrase "and cases cited therein."
All right.
I must have the old book because I don't have a chapter 3B at all. I haven't updated it. So the rest, does anybody have theirs in front of them? There's no chapter 3B. I think we should double check.
Which one are you in? Are you in the professional responsibility one?
Yeah, this one, right?
Yeah.
But I
Have
only
you done your
3.
updates?
It's in a box somewhere.
That's your answer.
But
Pocket part.
I better go look. I didn't
updated.
realize that.
Point taken, though. We can take a look at whether or not there's
Well,
more
it's
better authorities to cite or
subheading B.
Hmm?
The reference is not to a separate sub B chapter or chapter 3B.
It's to the entire chapter, 3B.
To
Yeah.
paragraph B of chapter 3, formation of relationships.
Oh, I see that. Yeah, that's the whole, yeah, I know. I have that section here. So it's chapter 3, subparagraph B, but it's an entire chapter. Yeah, I think that's kind of an odd site, frankly, for discussions of
It's a
factors.
voluminous site. We've cited to
Yeah.
a large source. Okay.
Yeah, it's like 2
We can-
pages long. It's, yeah,
All right.
3.
So we can look at that. We can look at that.
Yeah. Or
So
more
should
than
we-
2, like several pages.
Are we ready to move on to the legal contracts discussion? And should we take a 5-minute break for everyone? We've been going a while.
Brandon, if you don't mind.
Yeah.
Does the committee want to see this opinion again before it goes out for public comment at perhaps the January meeting, or does the committee think Dan, which I think 2 things. One, I think the working group for this opinion currently is Dan. So that might be something to talk about very briefly. And then either way, does the committee want to direct Dan and hopefully others, as well as staff, to authorize this for a public comment following these changes, or otherwise, or wait to see it again one more time in January?
I'd be more comfortable doing it without another meeting consideration if there was somebody else on it besides just myself. But
Yeah, I want to see it again. So I will join Dan's working group unless
I'll
everybody
join
wants to see
too.
it. Okay.
Yeah, since Dan is also helping with the in-house counsel opinion, I feel compelled to join his working group.
So
I'm happy to
So
jump
do
on
we
it.
need a vote now to authorize the working group to work with staff and then circulate this?
You would, if that's the will of the committee, yes. So you need a motion.
That sounded very majestic. The will of the committee. Let's test the will.
let
of
it
the
be
committee.
done.
Yes. Yes. Let's take a vote on this, and then that will tell us whether it's the will of the committee, right?
Motion to vote on whether it's the will of the committee.
Yep.
I'll second it.
All right, I will take the vote. Brown, Bradley, Chivers,
Yes.
Guzman, Mark,
Yes.
Mercado. Was
Give
that
her
a
a
yes,
second here.
Eleanor?
Let's give her a second.
That was a yes.
Okay, thank you. Munoz,
Yes.
O'Reilly,
Yes.
Poindexter,
Yes.
Ravi,
Yes.
Starr, and Krieger.
Yes.
So that's unanimous, yes.
All right. Great. So we should move on to the illegal contracts. Does anyone need a break? Should we power through and then go to lunch? Should we have a vote on a break? All right, we're gonna take a 5-minute break. All I need is one hand for a break, and then we'll come right back. All right, so we're back, and I'd like to thank Sarah for continuing to take the lead on this next opinion. And I will turn it over to Sarah for an explanation of where we stand.
Sure. And so this is an opinion that's gone out for public comments already, but it's been quite some time since that happened. And part of the reason we had this opinion on hold a little bit was because there were a bunch of different pending bills at the state level and FCC level, or I'm sorry, FTC level, that might bear upon this opinion. An example used in this opinion, which is an illegal non-compete clause, and whether an attorney who includes that clause in an employment agreement is engaging in conduct that violates Rule 1.2.1. And recently, and I think we reported on this at the last meeting, a California state bill has passed, which would become effective on January 1st, 2024, and that would make it unlawful to include a non-compete clause in an employment contract that does not satisfy an exception, and would also include entering into that agreement without an exception. And that's referenced if you scroll down to in this revision. And then this isn't fully revised to address that, but that's referenced, I believe, in footnote 1. I could pull it up on my screen. Oh yeah, so footnote 3, sorry.
Sarah, should we quickly mention that some of us might have reviewed not the latest?
Oh yeah, sorry.
Yeah.
I should have brought that up sooner. So the version that was circulated in advance of the meeting prior to this morning was an earlier version of the opinion. And it did not reflect the latest edits that were made. So this morning, I forget exactly around what time, a little after around 9:30 perhaps, Angela circulated the most recent version. So in case you looked at it in advance, you wouldn't have seen these edits. So I apologize that I didn't catch until this morning that the older version was circulated. So the footnote 3 kind of summarizes what this new business and profession code section states, which would make it unlawful to include the non-compete clause in the contract or to require an employee to enter into a non-compete agreement. And part of the public comments we got, even though we used the non-compete as an example and the purpose of the opinion was intended not to be limited to that context, but to address an attorney who includes any illegal provision as part of a contract, and whether doing so would violate Rule 1.2.1 or other rules of professional conduct. And but some of the feedback we got, because we did include the particular example, was feedback from attorneys concerned about the fact that the Business and Professional Code Section 1600 makes those contracts void, and even though some case laws suggest that also violates unfair competition law, that doesn't necessarily reflect conduct that is a violation of a law, and merely including an illegal provision or a void provision is not conduct that violates the law, and such it wouldn't necessarily violate Rule 1.2.1. I think, so we had talked about maybe using a different example in the past, or not including an example at all, and we never really reached a consensus on that. But now with the new with the change to the Business Professions Code, it does now clarify, and I think that would resolve a lot of the issues from the public comments in terms of whether merely including a non-compete that is in an employment agreement is conduct that violates the law. I think it's clear that it does. And so I think the conclusions are clearer now. There's also an issue about whether we should continue to revise this. The initial reason for this opinion stemmed from, a request that was focused on non-competes in particular. And that's why the opinion initially was focused on that as an example. Although the intention, my understanding was to really address this in a broader context and not limit it. So I can see some use for it still, even with this change in law that I think makes it pretty clear. Although I don't know that it's necessarily clear to people who don't practice, legal ethics or professional responsibilities, that it would necessarily be clear, because the statute, which doesn't directly state that this is conduct, if an attorney does this, that would violate the rules. So it still might be useful, but I wanted to just pause and give Erica a chance to talk about it. The other edits were more we just made very preliminary edits to show this change, and the other edits were to eliminate some duplication. There is one issue that I wanted to discuss too, but I'll let Erica kind of weigh in now, because she was helpful in identifying this change in the law and helping with the edits.
Thanks, Sarah. So for me, it's kind of a big picture question for the committee. So, if the statutory changes make it clear that non-competes are in fact illegal versus unenforceable, I'm not question one is there still utility in having an ethics opinion that says not only is that a violation of the statute, but it would also be a violation of certain rules of professional conduct? If yes, then I think this opinion, still has value, obviously. If no, and the committee doesn't think there needs to be an opinion that addresses that particular issue, I think the question then becomes, should the opinion address other illegal contract provisions versus unenforceable contract provisions? Are there other illegal versus unenforceable contract provisions that we could provide examples of? And then, adding unenforceable contract provisions, not necessarily illegal ones, a violation of perhaps not 1.2.1, but other rules of professional conduct related to, misrepresentations and those types of things. So I think maybe engaging in like a sequential analysis of this might be helpful for the committee.
So I'll just, my general thoughts, and I will start every discussion of this opinion with a standing apology, because I was very much in favor of exploring this ground when the opinion idea was floated. I tend to think that now that we have a law that says the mere inclusion of this kind of clause is a violation of the law, right? Not just unenforceable, but is a violation of the law. The fact that it is also an attorney assisting with it would be a violation of 1.2.1 is potentially so obvious and unassailable now that I'm not sure about the utility of the opinion. The other point is that the requesters of this opinion were really seeking, I think, help trying to keep these sort of chilling effect in terrorem clauses, unenforceable clauses, out of, as a public good. These are wrongful things causing harm, and we got to stop attorneys from helping with this. Well, this law change much more cleanly addresses, that goal. And then I think the much more fascinating and controversial aspect of the opinion in this state is would focus on unenforceable clauses, set aside illegality entirely in 1.2.1, clauses put in contracts that are known to be unenforceable solely for the chilling effect to scare a party who might believe they are enforceable. And whether that is improper, unethical for an attorney to participate in that for a client, or maybe even in attorney-client fee agreements at all, right? There are things that are in attorney-client fee agreements that are not enforceable, but have a chilling effect on clients. And I'm not aware of an opinion addressing, we've danced up to it in the conversion clause opinion, but that the mere fact of putting these things in an attorney-client fee agreement, knowing they're unenforceable, but they're going to scare the heck out of your client, whether that's unethical, that's a not a 1.2.1 issue. It's a fascinating issue, a controversial one. But to my sense, there's a part of this opinion that we could explore further, which is the misrepresentation or, that kind of thing. And I don't really think the illegality hook is still necessarily valuable anymore. That's just my 2 cents. Oh, I'm sorry. I see it's the little digital hands. My apologies. Cassidy.
So I kind of have a little bit of a different take, because the question of whether or not these types of provisions are actually unlawful or illegal is made clear by the statute, but the fact that there's exceptions that may apply don't make it so clear that when you have this particular provision in the agreement, with perhaps, circumstances where the exceptions of, like, if it's, limited by geography, right, or by time, are those the exceptions? Then it's not illegal.
Right.
So, so it's not so much whether illegal versus unenforceable, but the lack of clarity with respect to a particular provision. And then what happens is that, then it becomes a litigated issue between the employer and the employee. I mean, potentially a litigated issue or a dispute as to the legality or enforceability of the particular provision. And so I think that I understand the reason for this opinion, and I get that in practicality, these provisions are used as a chilling effect. And I think that's, wrong. But I hesitate to make such a bold statement that, it's clear that you just can't have these provisions in employment agreements because there are exceptions to that unlawful provision. And then my other point, Brandon, on the on attorney fee agreements, where there's, clearly improper provisions in fee agreements that may be used to chill client behavior or conduct or whatever. The BASF just issued an opinion on improper provisions.
Oh,
And I don't know if, just so, but it's not, it doesn't have to do with illegal provisions, but it may be helpful to that point. And that was last September or something. So I don't know, I still kind of grapple with this opinion, even with the new statute, because non-competes are not per se illegal, because there's exceptions to the statute.
So Cassidy, just bottom line, does that suggest to you continued utility in this opinion, or that it is misguided?
I think I don't know. That's my problem, is that, if a lawyer, if you get a non-compete that it's clearly no exceptions apply and it does violate the statute, and what the client is doing, you should not participate in that, right? But that kind of goes to, so it's very similar to, facilitating and participating in the client's fraud. And that's what kind of it is. It's fraud, because you and the client, you and the company know that this is not gonna, what the provision is intended for, that it's not legal, and that the only reason why it's in there is to, is to prevent the employee from leaving and competing. So that's improper. That's close to fraudulent. So then maybe that gets into, this is more about a misrepresentation analysis as opposed to a violation of law analysis under 1.2.1. But then what's the example of violation of law? Like, why is that in there? I keep going back to that, that's the problematic provision is the rule itself. We're really struggling to interpret that, I think, is how it applies in, outside of the fraud and criminal context of the rule.
Joel?
Yeah, listening to your comment, Brandon, the example that came to my mind was, we now know that it's improper to bring a strategic lawsuit against public participation to chill some otherwise protected conduct. But that statute, which informs us of that, creates its own remedy, which is attorney's fees and a court procedure. And arguably, we shouldn't be doing anything other than saying that's what happens to you, beyond what's provided in the law. And I'm wondering, now that there's a law on the specific topic that was addressed in this opinion, and perhaps there's others that would have their own laws which talk about remedies and violations, I'm kind of convinced that maybe we don't, this isn't an area where we now need to venture.
Any other thoughts from members?
What is, am I on mute? Wait,
No.
where am I?
We can hear you.
I lost my face. I mean, not to put her on the spot, but what does Sarah think? Because she's working.
Yeah, so I still think there could be some usefulness to the opinion, despite the fact that now, the BMP code has been revised to clarify, and it just so we might want to put it on the screen, but what it says is it shall be unlawful to include a non-compete clause in an employment contract or to require an employee to enter a non-compete agreement that does not satisfy an exception in this section. And Cassidy, this doesn't really turn on my analysis as much, but just in response to your comment, the exceptions are pretty narrow. So it's not just like in other states where it's, you can have it if it's limited to time period or something. It's really limited to like the sale of goodwill in a partnership, or it's super narrow. So it wouldn't.
Wait, so there's no so I haven't looked at the rule, but I thought it was the exception was geography and time.
No,
That
you're
doesn't.
thinking that's how it is in many states, but not in California.
Are you sure? And
Yeah,
have I
I'm
been
sure of that. Yeah. So,
Okay.
but there are exceptions, but they're very, very limited exceptions in California. And so, but my point is though, I feel like, so it does say it's unlawful to include it in an employment contract or to require an employee to enter a non-compete agreement that does not satisfy an exception. And I just feel, and then rule 1.2.1 says a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is a violation of any law. And just based on the public comments we got to our initial draft opinion, where our initial draft opinion was assuming that the non-compete was a violation of law. That was the premise of the opinion. And and people still felt that, well, is that really just because is really including a provision that is unlawful? Is that truly conduct that the lawyer knows is a violation of the law? I felt like we got a lot of comments on that point. So I feel like the public wasn't clear on that. And, I feel that perhaps we co-prac attorneys who practice in this field feel like, oh, of course it would violate 1.2.1 and other real provisions relating to, what we're talking about, including a legal provision for its chilling effect, which we also address in the opinion. Of course that would, and it's now clear because of 16, what's on the screen here, the revision to the BMP code. I don't know that that's necessarily clear to the public, just based on, what I've read in the comments. So I still think it's useful, and I don't think it should be necessarily, if we were to consider the opinion further, I don't think we should limit it to non-competes necessarily, because I do think there are other illegal provisions that, lawyers might include for their chilling effect. I can't think of one offhand, but I do know, it might be helpful to look at, Cassie, you mentioned the Bar Association of San Francisco's legal ethics opinion that was recently issued. And when I look at that, it looked like it was also addressing, unlawful. Are you talking about the one about fee agreements?
Yeah.
Yeah. So, I think that was addressing some unlawful provisions in fee agreements too. So it wouldn't necessarily, I don't know. I don't think it should be limited to the non-compete context. And I still think it's not necessarily obvious to everyone, even though we might feel as a committee that it's just obvious. So that's just my opinion, but I do agree. I do understand what Brandon's point was too, that, the initial reason for this opinion, the ultimate objective of some of the people who requested it for just the chilling effect of non-competes generally, that has been satisfied by this legislation. But I just still don't know that attorneys necessarily across the board will understand that this conduct of including a legal provision would violate rules of professional conduct. And that's just based on my review of the public comments we got. But I see Joel's hand is raised, so I'm going to pause.
Yeah, my only reaction is that, as with the anti-SLAPP situation, in my mind, now that you have a law defining what's legal, and offering whatever exceptions it offers, I think the existing rule, which says you shall not include an unlawful provision, is as far as we might go, because if there are exceptions, then the duty of advocacy might require the attorney to advocate that this particular clause falls within one of those exceptions, or that this particular lawsuit is not an anti-SLAPP motion, but I mean anti-SLAPP suit, or a SLAPP suit, I should say. Or so you have a duty to advocate, and so then it's your obligation as the attorney to comply with the rule and decide whether you have a good faith belief that it's not unlawful. And if you can't come up with one, then you should be disciplined under the existing rule.
Right.
Yeah, I agree with you, Joel, on that point, but just to be clear, the opinion is assuming that it's not subject to any lawful exception. So all the conclusions that we're reaching are assuming it's not subject to an exception. So we're not really getting into a situation where it might be subject to exception under the Business Professions Code.
Right, but just one thing, and I wanted to point out, because I know partnerships agreements, are what an exception, and that's where you can have a non-compete clause as long as it's narrowly, it's limited to time and geography. That's in one of the statutes there. So if you have, it's not an employment agreement, it's a partnership agreement, and it's when the partner, wants to leave the partnership and start his own business and compete with the usually it's a lot, that's where I deal with it, rule 5.6, but also the Business and Professions Code, and it's sorry, I had it up and now I lost it is 16602 partnership agreements. So so that would be a situation where there would be a question of it being illegal, or falling under the exception, that particular exception. So like law firms who have partnership agreements and they're presenting, and they're making somebody partner and they have to sign this agreement that's not negotiated and it contains this non-compete and it's not, so that's kind of a question, is like, are GCs of law firms subject to this opinion? You know what I mean? That would be a real world scenario where they have to consider, when there is a non-compete clause in a partnership agreement, whether or not it falls under the exception, it's an appropriate non-compete, or it's, or does it not fall under the exception, and then it's under 16600.1, the new law, and it's illegal. And that actually may present a dilemma, that if the GC is presenting a partnership agreement and they're concerned that they're going to be disciplined for possibly having an illegal, for presenting an illegal contract to one of their potential partners. Does that make sense, or am I off base?
I don't think I'm quite understanding, because if it's subject to a valid exception, it wouldn't be illegal. So what? I guess I'm.
Well, but the issue is it set that maybe maybe it is or maybe it isn't. But the lawyer who's trying to figure out. I mean, it's what Joel said. If you in good faith believe that an exception, but I guess. Yeah, I mean, I guess I would be somewhat concerned about this opinion in that particular context. Because it's a situation where exception, there's an issue. It's whether it's illegal, maybe a real issue, like whether or not an exception applies, may be a real issue, and so it will actually have the reverse chilling effect, on the GC who's participating and presenting that contract and doesn't want to do so for fear they're violating this ethical rule.
Yeah, I understand now. I understand your point, Cassidy. Sorry, but I did want to point out that we did try to address that in the draft opinion, the concern you raised. And I'm just pulling it up. And the partnership I thought was also limited to like a dissolution type thing. But here's the thing we trying to pull up the draft opinion, sorry. And it's on page, I guess, 3 of the red line that I'm looking at. But basically it says, you know, what we're not intending to address here, which is a situation where the lawyer knows a court has held a provision to be unlawful, but nonetheless has a good faith belief that the ruling was incorrect. Another court in the controlling jurisdiction has ruled or would rule otherwise, or the provision might be enforceable against the person who's being asked to sign it under reasonably foreseeable circumstances.
Yeah.
We were trying to make it clear that really we're intending to address situations where it's clearly, you know, a violation of the law and not potentially subject to an exception. And we could probably make that language clearer.
We had, at some point in the long history of this opinion, we had once talked about divorcing it entirely from any particular context, right? Just talking about it conceptually, because, you know, these are all complex areas of substantive law.
Yeah.
And as lawyers, we're all fighting the hypo, because your hypo here is really clear, Sarah. This thing's totally illegal. And
Right.
it's really illegal. And it's very hard for us to just accept that, especially presented with a real statute that has exceptions and all of those things. We had talked about, you know, whether it made sense to not tether it to like an actual area of the law. I don't know if that's a good idea or a bad idea. I'll be honest, it doesn't really address all my concerns, but it might address this particular issue.
Well, selfishly, my concern is the partnership agreement scenario, because I deal with that all the time. But, and so, you know, I mean, frankly, I don't know. Part of me feels like maybe we need to be more specific to say this. I mean, because this is a real problem in the employment context. You know, how this all came about was because this is what was happening. You know, and
but then I
believe
thought
that
about.
can be.
I'm sorry, I didn't. I'll let you
No, go
finish.
ahead. I'm done. It's okay.
Well, so when we get to the chilling effect, separate from the illegality, whether or not something is illegal, when we get to the chilling effect, the implications of this draft are really profound, because we have attorneys do this all the time. There's $10 million in liquidated damages if you breach this lease or whatever it is. You know, these are ridiculous provisions intended for their chilling effect that are all over the place. And is that a misrepresentation and an ethical violation or not? That's a huge question. That will provoke a huge response, and it's a big deal if we opine on it. And that's completely separate from whether things fit on the 1.2.1, which turns on a really confusing issue of whether it's illegal in the sense that it's not enforceable, or the mere act of including it violates the law, which is a tough distinction that we've spun around on a lot too. So, Joel?
Yeah.
Joel, we've lost your picture.
Oh, I guess I'm frozen there. Can you hear me?
But we can hear you fine.
Okay, well, I'll figure out why I'm frozen some other time. But unless you're going to identify each one of those specific possible illegality situations and go through the nuances of them the same way we're doing or proposed to do with these employment agreements, what utility are we offering other than an incomplete recitation of what's already in the rule, which is thou shalt not include an illegal provision in a contract?
Well, the rule doesn't quite say it that way, right? Isn't that one of the problems? You will not assist.
It doesn't say it in that way. And just to be clear, too, many of the public comments, including people who are attorneys, felt that including an illegal provision in a contract does not necessarily violate Rule 1.2.1, which states a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal, fraudulent, or a violation of any law, rule, or ruling of a tribunal. And at least
Yeah,
some of the public
Sarah,
felt that doesn't encompass, merely including a legal provision in a contract.
Right. Sarah, just to jump on that public comment on that issue, I thought that was just a fascinating, like, really important dancing on the head of a pin weirdness, right? Like, is it conduct or is it this or that? And to me, it turns on whether the inclusion is illegal or whether it just won't be enforceable, right? And it, clearly on this statute, to include a prohibited clause in the employment context is a violation of the law, right? So to me, it's really obvious that you are assisting a client in conduct. I mean, the contract doesn't proffer itself, draft itself, sign itself. It's conduct, right? But I know some attorneys disagree from the public comment. But for me, the much tougher question is like, well, the liquidated damages of $1 zillion is unenforceable. Is it illegal? I mean, the law won't enforce it. I think that's a tougher distinction. But Sarah, I did think that I strongly disagreed with the attorneys who think that it's in a contract, so it's not conduct. And you're still helping them to engage. I don't know.
Yeah, I I agree with you, Brandon. That's one of the reasons why I think potentially this opinion still has some value.
Right.
Because I don't think it's as crystal clear as we might perceive it.
You may be right.
And I see Erica has her hand raised.
I'll just add to that point. There was a different statute that was pending as part of, I don't remember the bill name off the top of my head, but it would have made it a disciplinable action to include a non-compete clause in a contract that didn't move forward. And so just for what that's worth, maybe that means it's of value in the opinion to make that step under 1.2.1, or maybe it's not, because that particular bill didn't move forward and this one did instead. Just thought that was worth reminding the committee of, because I believe that bill we did look at the last time we looked at this opinion as well, substantively.
What were the two differences between the bill, what you just said? Sorry.
Let me pull it up. I believe I still have it as one of the bills I'm tracking, even though it didn't move forward. But that bill, it was AB 747, and it would have made it under the Business and Professions Code cause for suspension, disbarment, or other discipline for any licensee to enter into with an employee, prospective employee, or former employee, every type of employee, basically, to paraphrase, or attempt to enforce any employee contract or other agreement on the licensee's behalf or on behalf of their client, a basis for discipline. So suspension, disbarment, or other discipline to do what we're talking about in this opinion as it relates to non-competes.
So it was specific to the lawyer entering into an agreement, an employment agreement that has a non-compete clause.
Enter into or
participate in,
to enforce on behalf of a client. So I can share the exact, it's really hard for you guys probably to hear it, especially as I paraphrase it, which isn't very helpful. But let me share what that old bill looked like just very briefly so you guys can take a look.
One interpretation of the existence of that is just that the legislature views this as their purview and they struck a legislative balance on this issue that we might not disturb, possibly. Sorry, Vikita, go ahead.
No, that's fine. I was just curious. I understand this particular, but wouldn't AB 1076 prohibit non-competes altogether?
Which one?
So for 2024, AB 1076, they're talking about it makes it unlawful for an employer to include a non-compete clause in an employment contract or to require an employee to enter into a non-compete agreement unless subject to a statutory exception.
You're correct. The question becomes if a lawyer, that's the employer's liability. The question becomes if the lawyer assists them in adding that provision. What is I mean, I'd argue there's a malpractice issue there, but is there also a discipline issue as well?
Yeah. This is 16. Oh, I see.
But
Okay.
this is what was not moved forward.
Right.
What shared on your screen is the bill that died in committee.
I mean, this is basically our opinion, right? I mean, and that's what Dan just said, you know, like if the legislature, but and this died. I mean,
I'll just add
Is
that
this taken further with or is this the law that was actually passed implies this too? Because that in conjunction with 1.2.1.
well, that's what no, it
Right. The new law plus 1.2.1 equals discipline. I don't know.
Yeah, well, that's what we're trying to figure out, right?
Right.
yeah.
I mean, the legislature had considered this, they analyzed it specifically, and they decided not to do it. If at a minimum, it means that they viewed as their job to make that determination.
Well, I just want to add the bill itself, AB 747, the bill that did not move forward that had that provision, was much more robust than AB 1076. So I think we would be making many inferences as to the legislature's intent to move forward with 1076 as opposed to 747, because there is so much more in what was proposed as AB 747 in addition to just that one provision. It's like a several page bill, whereas 1076 is, pretty succinct.
Eric, I disagree, because obviously when the legislature went forward on 1076, they knew of all the provisions in the other bill and could have included any of them as amendments going forward. And if you look at the normal way you analyze legislative history, I would have to agree with Dan's approach on this. They could have and they didn't.
Well, maybe they wanted us to deal with it.
They probably would let us know if they wanted that.
Nikita, is your hand up because you still have another comment, or?
Yeah, I'm just confused, and it could just be me, but I'm just a little confused. But if non-competes are illegal, then why would? And you all are looking at me like I'm like a deer in headlights. I'm so confused right here. I'm trying to follow what I'm confused because of that particular bill I just quoted, but also with Senate Bill 699. Why would an attorney help with a non-compete when non-competes are unenforceable?
Well, so there's two reasons we're getting at here. One is that the attorney might say, well, there's certain exceptions that would make this non-compete okay, and arguably we fit in those. So the attorney is going to take that point of view. But the other one is the new law that says that non-competes are not just unenforceable, but it's illegal to try to put them in the contract. I guess my point earlier was that attorneys do that with all sorts of things to scare the hell out of the other side of the contract in ways that are not legally enforceable. And do we want to take a stand against that, or is that just being a lawyer in the world? I don't know.
Well, or the legislature decided that the existing rule already binding on attorneys about illegal contract provisions generally was sufficient. And that's why they didn't add anything more specific, including the amendment to, what was it, 6060? I can't remember what it's not updated for me. This is some Professions Code Title VI.
That's kind of the key to what you're kind of saying is if it's so obvious, then what are we talking about?
That's exactly what I'm saying. That's exactly what I'm saying. I mean, you can't.
That's where it started. That's where Brandon actually started. Should we even have an opinion like this? If it is yeah.
I mean, if it's illegal, right? I mean, you can have agreements that deals with other things, protecting trade secrets. But if they've said you cannot have non-competes, then there's just no way around it.
Yeah, well,
that's why I was confused. So
for that issue,
right, for that issue.
You're repeating a lesson I learned years and years ago, not only from COPRAC, but from arbitration advisory or whatever, sometimes you don't always agree with what the legislature or the courts do, but then that's where you're stuck with. So I think we're stuck.
Yeah, I agree. I agree. I think it's a slippery slope that why would we even have an opinion on this one? So,
The first law of everything is don't do anything you don't have to do. That's number one.
exactly.
Yeah, well, that's my lean, and then I do throw out there without any particular goal. Do we want to deal with that second half of the analysis in this opinion, which is truly the chilling effect, unenforceable, leaving aside illegal entirely? Is that too fraught, or is it worth an opinion looking, or even contemplating an opinion looking at the ethics of intentionally putting unenforceable things in a contract for chilling effect?
I think it's too fraught. My 2 cents, and take the partnership agreement example. I draft these all the time. You're talking about sophisticated people, and there's so many different choices. I don't know if it's going to have a chilling effect. And so what
Right.
if it does? Depends on who's reading it,
Right.
Figure it out or don't. The legislature makes decisions when there are people like an employee in a position where it's not negotiated and you have a lack of power and things like that. So, and I don't spend time, Cassidy, I don't know if you do, but worrying about whether law partners have been chilled. They're fine.
Right, like the ones who are reviewing the partnership agreement. Yeah, I mean,
By the way, those
Yeah,
partners are the
right,
ones who
right.
take those provisions out because they think one day that's going to apply to me if I want to
Right.
leave,
right, exactly. But okay, so as far as the illegality part of it, are we saying now that because the statute, I mean, part of what we may be saying now is that because of the new statute, like employers just will not be putting these provisions in employment agreements for the chilling effect because it is so clear. You know what I mean?
Or
It's
if they
just-
do, they're already breaking the law, and an attorney who's assisting them is already violating 1.2.1. In my view, but Sarah made a really good point that based on the public comments, a lot of lawyers are going to say, no, I can draft this totally illegal provision, and it's not, and I didn't do it. It's my attorney, my
right.
client.
It's
Well,
going to continue. I don't know if the statute's going to change anything, and the need for this opinion may still be valid.
Well,
You
Should we
know?
also issue opinions about whether people really understand murder or where,
Right.
do we know they really understand it, what that
Yeah.
means?
Well, but
Yeah, no, I
I could participate testifying as an expert in the lawsuit where the client says, oh, I relied on my attorney to put that in there, and
Right.
I didn't know it was illegal. And then the attorney's going to have the 4-page memo saying you can't put that in there because it's illegal, and that's how it's going to get worked out. It's not going to. You don't have to hit him with a baseball bat further than that.
I think there's going to be a lot of attorneys that say, hey, this thing's illegal now, you can't do it. I mean, but if you really want to, it's your company. And then the attorney has done the thing. I'm afraid of that.
Maybe.
And what we're
Maybe
seeing
the-
is a lot of employment. Oh, I'm sorry. What we're seeing is a lot of employment law attorneys are saying that right now. Like, no, you can't put that in there. And if you have it in there currently, according to this law, you got to notify your employees that by February 14th, it's void. So attorneys are literally saying, no, we're not doing it. We're not writing it now. We will write something that will say we will protect your trade secrets, but we're not doing any non-competes.
Those are the good attorneys though, right?
I know we're doing it. I was just giving an example.
Yeah.
Now they're not all good. Let me just say that. But
Yeah.
So
I think this should be the subject of, this is more of like the subject of a hotline or alert or something, like to let lawyers out there know about this new statute. You know what I mean? It's more of an alert, like, just so that they know about this new statute. If you're an employment lawyer, you better know about this statute. And, because if you're gonna put a non-compete in an employment agreement, it's gonna violate the statute and you're gonna violate 1.2.1. And that's
Cassidy,
it.
that was so well put that it almost sounded like you were volunteering.
Well, I mean, really,
Second.
it's just to to truncate the opinion, and like that's it. I'm happy.
So I'll call on Erica and then Sarah.
Well, I don't disagree maybe with what Cassie just proposed, but I do think there are still the value in some of the opinion is the like report up withdrawal obligations, the 1.16 organization as client type issues with the organization that you are advising who does not heed your advice and continues to put that in their employment agreement.
1.13, 1.16,
Exactly.
yeah, like you gotta
So,
withdraw.
yeah, so I do think it could be a hotliner versus, you know, an ethics opinion for that component of this opinion. I still think we need to talk about the other section of it, but as it relates to non-competes. But I do think those additional concepts are of value in whatever this form this ultimately takes, if any.
Sarah?
Yeah, I was just going to say is I do, you know, agree that employers should know if they're aware of this statute, right? That they're not going to be including these illegal provisions going forward, and they shouldn't be. I don't think, you know, all employers necessarily follow the law. And so I think some might still include it for the chilling effect. And I don't think it's clear to attorneys necessarily what rules of professional conduct or ethical responsibilities they might be violating by assisting a client in including this provision or trying to enforce it. I don't think that's necessarily crystal clear. And one other point is that I can see like a kind of what might happen going forward, because I've seen it a lot in companies that operate in many different states, and they have policies that apply across the board, and it might have a non-compete as part of that, and then at the very end say something like, you know, except in states where this is prohibited, you know, some sort of disclaimer at the end, right? And that still has a very chilling effect on employees. So they might be, you know, so there's still issues I can foresee coming up that just aren't necessarily straightforward.
So Sarah, I'll go to Joel in 1 second. What you're suggesting strikes me as definitely useful for those public commenters we saw who think the lawyer is scot-free in the drafting of the bad provision. That is useful. I would, if we were to go down that road, suggest we consider not talking about the misrepresentation analysis or the implicit representation to others that this is true or enforceable or not illegal. I just think that's a much bigger and distinct can of worms that applies beyond illegality to anything unenforceable and chilling. What you're saying would be a more narrow application of 1.2.1 to a definitively illegal contract provision. And that might have some value to those folks. And so I'm just sort of, that's my take on what you're saying there. Joel?
Brandon, I hold to the view that you expressed at the outset that in light of the change in the law, I kind of doubt the continuing utility of this opinion generally. However, what I would suggest and perhaps move is that there's no doubt that there has been a change in the law, and we have received public comment, which would require a rewrite of this opinion, and that those who feel that it might be restructured to give us some continuing utility over and beyond just the text of the current rule and the law, presented at the next meeting, and let's see.
Cassidy?
I'm kind of going back to whether or not it's really clear that anti-compete. Well, because what about a provision in an employment contract that is like competition neutral, but it has the effect of being, may have the effect of being a non-compete. So like imposing a financial penalty for leaving. You know, you gotta, so it's, but it's not like you can't compete. It's just, you gotta, you know, forfeit. I mean, in the partnership world, it's forfeiting part of your capital account or something like that. And so there, you know, so there's a lawyer kind of like, you know, advising the client about like, well, how do we get around this prohibition to make it competition neutral so that it's not illegal? You know, so then there's like a gray area where, you know, you could, I mean, and then that gets into like the good faith, is it illegal? You know, belief that it's not illegal, and then you can participate in, you know, you can actually participate in drafting and presenting it to the employee. You know, it's not like it's clearly intended to just chill
Right.
the employee's conduct. So anyway, I'm back to that now. I'm back to thinking like, well, you know, so there are scenarios where it's not absolutely clear that it's illegal. And maybe I'm wrong about that because I have looked at this, but I haven't looked at this and how the new law will affect the cases that talk about, you know, competition neutral provisions and whether or not they violate the non-compete prohibition. So, my 2 cents.
I am going to ask Sarah, who's put in a lot of time and effort on this. Sarah, how would you like to proceed? Do you want to ask the committee for a vote on any particular approach, all up or down, or where do you want to take another crack at modifying it and bring it back? What do you think would be helpful for you?
Yeah, and I, just so you know, I don't feel like particularly, you know, tied to this opinion. I wasn't initially the lead drafter, but this has been around for a while. So I've gotten kind of thrown into this one, you know. So I'm not particularly, you know, feel super strongly like, oh, we must proceed. I mean, I do feel that it does have value still, but you know, putting that aside, I don't really think it makes sense to revamp it and revise it if the opinion of the group now, which I'm hearing from most people, is that they don't feel that it continues to have value in light of the amendment to the BMP code or the new BMP code subsection. It seems like most people are saying we feel it has value because attorneys should know, obviously, that would violate the rule of special conduct now if you were to include a non-compete in an employment contract that's not subject to a valid exception. So it seems like that's what most people are feeling, and if that's the case, I don't think it makes sense to move forward. I wouldn't want to invest the time in even making those revisions, you know, if we know now that people just don't feel like that would have value. You know, I haven't really thought closely about the second question you raised, Brandon, which is, should we move forward? And that might be a separate vote. Should we move forward with opinion? I don't think I've heard a clear answer to this question from the group on a provision that's void or unenforceable, but not necessarily illegal, and the consequences of that. That's something we could still consider. That was something where I think a lot of people felt we initially were before this change in law, that people felt that non-competes were void and unenforceable, but not necessarily illegal. So I think there was a lot of concern among this group and among some of the public comments about situations where it's just void and unenforceable, and whether that would violate any rules or not. So I'm not sure about the answer to that question. I'm thinking maybe it does not make sense. I did, you know, Cassidy made the suggestion too for the, you know, ethics hotliner, or I forget the name that we now use, but, you know, we could consider that. I'm not opposed to that, but I don't think it makes sense to move forward if people feel that it's just, you know, of limited value.
Erica?
Yeah, I agree with Sarah. And I would just add that I think that that's like the straw poll or the motion or what have you is to move forward with any version of an opinion or otherwise that addresses the 1.2.1 issue, and then go from there.
So how would we, sorry, Erica, can you sort of like spell that out like systematically here, how we move from here to there?
Yeah, I think someone could offer a motion to proceed with a COPRAC work product. We can defer as to whether it's an opinion or otherwise, that addresses non-competes and whether they violate whether assistance in drafting a non-compete would violate 1.2.1 and then require, you know, those further duties if you advise that it's illegal, and your client decides to proceed with it.
Does
So I
anyone
think-
want to move that?
So
I'll make the motion.
I'm a little confused. I'm sorry by that motion, what we're moving for. So I thought initially you're talking about moving for, do we move forward with you're saying opinion or otherwise? So are we voting on an opinion or an ethics hotline, or I'm just.
I think just the concept would be my recommendation. Like,
Why
does
don't-
the, go
Why
ahead.
don't we vote on the opinion first and then separately vote on whether, depending on how that vote turns out, whether we would want to do the hotline thing or whatever. Is that okay?
Yeah, I think that makes sense. My preference would only be just to focus on the illegal non-compete issue and then take the other half after.
Okay. Does that make sense to everyone?
Yep.
I will move for an up or down vote on whether we continue with an opinion on 1.2.1 in this context.
It's like that.
Vikita, that was you making the second.
Can I ask
was.
a question?
Let's see,
This
yes.
is, the opinion would be taking out the discussion of illegality and continuing with the other concepts.
No, this is the obverse of that. This is just about 1.2.1's application to this statute, sort of, you know. And then we'll do a second vote about chilling effect stuff, you know, that's not illegal.
And a yes means you vote to have an opinion on the illegal 1.2.1 issue.
Okay, I'll take the vote. Brown? Bradley? Shivers?
No is don't going forward with the opinion, right?
Correct.
No.
Okay, so I'm confused.
Did I do this
Again.
wrong?
Yeah.
It got convoluted.
So, Vikito,
it did.
should we? Do you have a
I'm sorry,
question,
Angela.
or-
Oh, it's
Yeah.
okay.
No, this is confusing. We're splitting this opinion in half. The first half is about the illegality hook. The second half is about misrepresentations for chilling effect, sort of. And now we're just doing a vote on whether we want to proceed with an opinion on the illegality of this clause and an attorney's drafting of it being prohibited. So Cassidy voted no.
So no means we're not moving forward. Yes mean we are
Correct.
moving forward. In the
Correct.
first part. Okay,
Correct.
part one, and then we'll deal with part two secondly. Okay, got
Exactly.
it.
Okay, so I'll continue the vote. Guzman? Mark?
No.
Mercado?
Oh, you're still muted, Eleanor.
But can't hear you.
Dude, I'm a no.
Oh, there we go.
Oh,
No,
there you go.
thank you. Munoz?
No.
O'Reilly?
No.
Poindexter?
No.
Robbie?
No.
Starr? And Krieger?
No.
So that's 8 no's. 0 yes, 0 abstain.
So we could have a vote on whether to have an opinion on chilling effect, you know, which is some analysis already in this draft. It might make more sense to have, I mean, what's the preliminary step? Like an outline on that issue? Because I think that's going to be a really controversial issue. So I don't think anyone's going to like green light an opinion on that right now, not knowing what the conclusions are and how it works. So, Joel?
Yeah, I still say I would vote no if this were up or down on a final product, but I don't want to have the chilling effect on this committee of prejudging that. If there are people who feel they can craft something that does have utility in some way to fulfill our mission of protecting clients and the public and the good name of the profession. So I can't vote against it.
Well, maybe the vote itself is premature. Maybe what we do here is we all take this wonderfully informative discussion to heart and thinking about whether any of us thinks there could be a coherent, useful opinion on an attorney's incorporation of unenforceable clauses for their chilling effect. That, you know, and then we can talk about it at a future meeting, because that's a whole new can of worms, right? And it's very important, and it's going to be very controversial and very challenging. You know, there's going to be examples that seem appropriate and some that are just beyond the pale, and what are the ethical implications and what triggers what. So unless anyone wants to vote on that right now, which is of course fine to propose, I would suggest we just think about that as one of our topic ideas.
And does anyone have an example that they want to mention about a unenforceable but not illegal provision?
Yeah. I mean, I think about it with liquidated damages provisions. I mean, I think our last president had every government employee signing NDAs.
The NDAs, yeah.
Yeah.
NDAs, yeah.
So maybe it's an NDA opinion. I don't know. But
Well,
I think,
that was, yeah, sorry, I was the one of his lawyers, there was the Alina Haba was trying to enforce NDAs, and that made me think about this opinion. Beyond that, I don't have any more comments.
and it's a really provocative issue, because we could, in the opinion, assume the entire purpose of it is chilling effect. This is something that's totally unenforceable, like a liquidated damage provision that the other side could never in a million years pay, and that has no relationship to anything. It would never be enforced by a court. But we see that sometimes. And it's not illegal. It's just never going to fly. But is it wrongful for an attorney with an attorney's ethical duties to be a part of it? Big can of worms. We
Brandon?
might never get to any coherent, but it's pretty interesting.
Brandon?
Yeah.
Just next week, I'm going to testify in a case where an attorney took a job as an independent contractor, but general counsel to a corporation, and he prepared the contract for a 5-year period, and he would get paid a minimum of $60,000 a month for the 5 years, and is now claiming that was he got fired because he was incompetent. He's now claiming that was liquidated damages, among other things. Now, I had no trouble in crafting about a 8-page report concluding, based on the existing rules, that he's wrong. He violated the rules of professional conduct in many ways. So I'm just pointing out that I think we have adequate ammunition. So we ought to be looking at this for what else do we need to say?
Yeah. Yeah.
And Joel, is that job open currently? Because I think we'll need that listing.
Well,
Well,
and
they got what they wised up after they read the opinion.
I'll just add, I think I am open to if the committee would like to having our office's staff work up something like this, starting with liquidated damages and NDAs. I think the NDA one is personally very interesting. And so Joel, maybe you and I can connect, and you can share what you can as far as the authorities that you put in that report.
Well, I think it would be totally amazing if staff wanted to get the ball rolling on this for us to consider.
Yeah. It may not be January if we actually provide a draft, but certainly.
Well, no, yeah, or just even some working concepts would be super useful for us to talk about.
Yeah, I was thinking an outline would be helpful.
Yeah.
If you're willing to do that, that would be.
I mean, a draft by January is inconceivable. No humans could do that. All right, so should we break for lunch and then come back and talk about the ethics of in-house counsel? All right. So how long do we take for lunch? I don't want to get the
we
number.
usually take an hour, subject to like imminent AI or CTAP or civility deadlines that don't exist today. But I will say that, you know, the in-house counsel opinion, there's a lot to talk about, I think, and there's also a lot to talk about in the planning session. So
okay, so here's what I will propose. I'm going to propose 45 minutes, but if anyone objects to that, no questions asked. So get your hour. Are we good with 45? All right, let's do 45 minutes, and then we'll see you all at whatever time that is. So thank you.
Okay.
I think that's 1:20 for everyone who's Bad math like me.
Thanks.
So Erica, I have a hearing.
All right, so we are back, and Cassidy is going to present this latest iteration of the in-house council draft and sort of tell us what's new and where we're headed.
Okay. So it's couple of things that I think it's in good shape, but there's a couple of kind of bigger picture changes that I think I want to talk about first. So the first question, the rule 1.9 analysis under issue number 1, I think is good, and aside from some further editing that can be done, but I don't, unless anybody has any questions or thoughts or anything about that analysis, I think it's pretty solid to move on to some kind of bigger questions that Dan and I were discussing. The other kind of housekeeping issue really quick, I don't know, sorry, I don't know if is this version with Dan's edits, Erica, but also with Summer Syed's edits as well? Because I don't think Dan got her version. Now I'm sorry.
This one, it does have SS notes.
Oh, it does? Okay. But then doesn't have Dan's notes.
Uh-oh.
It does have Dan's comments. So comments come in as like DO, as you can see on the screen. They don't show as comments for purposes of posting. So I don't know.
Okay, so that's Dan. Yeah, I think that's your comment, Dan, is that I think question 3 can be eliminated, for example. I think that's what, right?
Yeah, they're in line. They're in line now. They're not.
I see. Okay, so I think they're all in there. So yeah, I want to thank Summer and Dan for doing additional edits on this, and I think my next task is to go through the just the edits and put them all together. But so I think the first part is fine, but we need to just finalize it, but I don't think it needs to be wordsmithed right now. The second part, which is on rule 1.8.1, the question is really, are we happy with the analysis, that the basic analysis that if we're talking about an in-house lawyer who is presented with an employment agreement, like a standard employment agreement with stock options as with any other employee, that rule 1.8.1 generally would not apply. But Dan and I were talking about, it's sort of on a continuum. On one end, when you have that sort of scenario, you would not be required to comply with the rule 1.8.1. And then there's the other end of the spectrum where you've got like a closely held company, or a startup where the lawyer is one of 4 shareholders, and it's the Passante case where the lawyer is basically negotiating his or her own stock options and ownership in the company, and it really and also being in-house counsel. And under that scenario, then 1.8.1 would apply. But then there's just sort of like the middle ground, and the purpose of this opinion is to provide the analytical framework for the lawyer to figure out whether the rule applies to them. And so I just wanted to kind of get input from the committee about whether that's, they agree that you guys agree it's the right approach. And then I also wanted to address Summer's comment about the Chisholm case that Dan and I talked about earlier, but I'll pause there and see if anybody has any comments about the second issue.
I do. I think you guys are doing a really good faith attempt to wrestle with that continuum you just identified. I am not entirely comfortable with it, which is not to say I think you're doing anything incorrectly. It is uncomfortable for me to think of business transactions between an attorney and a client where 1.8.1 doesn't apply because we have analyzed the power dynamic. For instance, it applies where you have an unsophisticated client and a sophisticated lawyer, or 1.8.1 can apply if you have a super sophisticated client. I mean, take out the in-house counsel portion. I would never want to suggest that if I have a client who is far wealthier and more powerful than I am, I don't have to comply with 1.8.1. And I just want to be really
Right.
careful with some of this,
Well, and that's the point. I mean, that's why this is specific to the in-house context, because we
Right.
have to take into account that the typical arrangement, oftentimes, or the typical arrangement is that it's both an attorney-client and employee-employer relationship.
Right.
And so there is, in that scenario where there is that, reversed leverage, that where the company is the employer, and, then we've got situations where it's, it just simply doesn't apply. And that's, yeah, I mean, but so I know, I mean, we're kind of just grappling with, how much, I mean, and I think that the value of this opinion is to make sure in-house lawyers understand that you have to go through this exercise to determine whether or not you need to comply with Rule 1.8.1. And that there is authority out there to say that it doesn't apply in every circumstance in which you are taking either, you are taking an ownership interest in your client, like in the ABA opinion.
Yeah, I think, and it's just, I think you guys are doing a great job of treading down this road. It's just very fraught because there's no other lawyer that gets to determine. For every other lawyer, the question about whether the rule applies is this a business transaction with a client, right? Not, and I myself will undertake to analyze the power dynamics. That's a tough, and then what guidance are we going to give about those dynamics? What is the turning point? Obviously a 4-person closely held company where the attorney gives himself ownership, describes his job duties, does all these things in ways that could be incredibly beneficial to himself. 10 shareholders, 20 shareholders, maybe another lawyer present. It's very tough. It's very tough.
Well, we do address, I did come up, and I think an earlier iteration, I think Sarah came up with some additional factors, but we have in here factors to consider in determining whether 1.8.1 applies to an in-house lawyer's compensation include, and then whether the lawyer was involved in advising. It's it's in the opinion if you want to scroll.
No, I see. I actually think that part's great. I think I'm just sort of hung up on this idea that the lawyer is going to be making their own determination as to whether a rule of professional conduct applies to them in this business transaction. And are we at all comfortable that these are the same factors that, the disciplinary department would look at too, if they even look at these sorts of transactions?
Yeah, I mean, I don't know, but I would hope, I mean, that's, I think, I don't think we're coming up with coming up with this issue and analysis whole cloth. I mean, that's why, we have the Chisholm case that the staff comment was questioning whether it applied. But it does illustrate that courts have looked at the question of business transactions between an in-house lawyer
Right.
and the company, and have looked at it to say, you know, this is a different kind of situation. This isn't
Right.
like, you know, a lawyer client. This is in this particular situation, we're talking about employer where, you know, 1.8.1 would not apply. And so there's that case. There is the Washington very brief opinion.
Right.
And then there's the ABA opinion, which talks about it as well, but the ABA opinion is not an in-house opinion. It's not specific to in-house lawyers. Where do I have it in the ABA opinion?
It's at the very beginning of the 1.8.1, right?
Yeah, hold on. Or does it only talk about one? You know what? I haven't gone back and looked at the ABA opinion again. Oh yeah, you're right. Okay.
Brandon, I have a question about what you're saying, but also some context. I think we all agree that in-house lawyers don't observe 1.8.1 pretty much at all, at least in my experience. They don't view their employer as their client.
Right, unless it's the closely held situation, right? I mean, I think there's the Fair case and the Pasante case is clear indication that if you're gonna like enter into a deal with a bunch of people to form a company or something, and you're gonna be the in-house lawyer, you have to comply with it. But then now we're talking about the traditional in-house lawyer with a legal department and all of that. It's the employee. Yeah.
Then the question is so the large legal department, or an established company that has this, and I don't think a lot of people view that in this way, but the purpose of this is really to suggest potentially for the first time for some of these people that they should view this that way. That's one. But then I think the other question is, do you think there is something about the employment status in and of itself that should be treated in any way differently under the rules, basically? Because you have a lawyer representing a client and the type of power relationship that exists there and the control that a lawyer can have. And then you have an employee working at a corporation, which is a very different power structure. The cases seem to suggest that, there are specific things about that relationship that should be considered to be different than the typical lawyer client.
I think you're right. I think, maybe I would want to, I love the part where we talk about the factors to consider. And I wonder if there's just a way, maybe that should be the beginning of the 1.8.1 section before we dive into the bigger analysis. I'm not sure. And maybe
that's not a bad idea.
Yeah.
Right. I mean, sorry, I didn't mean to interrupt you, but I was kind of thinking that when I pulled it, I'm like, you know what, this is kind of buried. I mean, maybe we need to, make it more prominent.
But I do think it's a good concern, and we have wrestled with this back and forth a little bit in the revisions because, and this is where it all started. You don't have almost any other instance where you say there's a category of lawyers for whom this rule doesn't apply.
And we start out saying the rules of professional conduct apply to in-house counsel,
Right.
But they have another layer. I mean, that kind of changes that dynamic, I mean, it really, you can't say that they don't apply.
No,
they do apply, but there's a different layer that suggests that they apply in a different way or something like that.
Well, and it's also like all these duties, it's a unique context because, fiduciary duties in an attorney-client relationship run one direction, but employers have all these labor code compensation duties to their employees that run the other direction. And honestly, I've only had this in my entire career come up like 2 times where there was an argument about, okay, this attorney in a relatively small organization wrote him or herself a pretty sweet deal with no compliance with the rule. And the client corporation wants to void that interest. And the attorney comes back and says, then you have violated the labor code and you owe me $1 zillion for all this. And you're like, I don't know the answer to these things, but, and it doesn't directly hit this, but it is just this one area where the duties don't run solely one direction, right?
Right.
So
That's right. I think you mentioned that like a year ago, and
Yeah.
that is actually a good point. And what, you know, I don't know if it makes sense to dive any deeper to like look into what labor code violations could exist for, you know, a company that uses 1.8.1 as a sword to, you know what I mean? Like where
Right.
the company's like has, you know, the upper hand, and it's their agreement, and
Right.
there was no negotiation, and then the lawyer wants their, you know, payout, and they said, well, wait a minute, there's no 1.8.1 waiver in here,
Right.
you're not going to get it. And you know, that's not fair.
No,
You
but
know?
but it is this is already a really dense and comprehensive opinion. I wouldn't want to go down
Yeah.
that road at all. But and I think you guys are doing a really good job. I mean, I think it's fraught. This has never gone out for public comment, correct?
No.
No, but
Really
yeah, and so
fascinating.
I'm just,
Yeah.
well, I'm having a hard time getting it ready for public comment. What I should have just cleaned it up more, because it could have been ready to go out for public comment. It just needs to be now cleaned up. But
I think if all this opinion said is one line, 1.8.1 applies to in-house counsel, don't forget, that would still be controversial in and of itself.
Totally.
Oh,
You're
you
right.
think? Well, yeah. I mean, because they don't even think about it. I know. I mean, so it'll be, well, we'll see what happens when it does go out into public comment. I mean, you think we're going to get comments like, this shouldn't apply to us at all, ever? You know, I mean, I think that it's going to be, I don't think it's controversial to say that 1.8.1 should apply to in-house counsel.
No,
in
except
many
that it's so
circumstances.
often not viewed that way, at least in my
No.
experience, right? Like,
Right, with the
but so
standard agreements.
part of the purpose is in part really to signal that fact is true, right? And that is, it exists already. It is true in the very beginning. These rules apply, and then the analysis goes through ways in which there may be more to the question than that. But I guess then, if there is something about the discussion that seems like it's creating an exception, a bright line rule for employees, that could be a problem.
Yeah, we don't want to go that far.
Right.
No.
Yeah. That's why the factors come into play. And maybe we need to flesh out the factors a bit more to provide more solid guidance. And I was, initially I was hesitant to do that, because that's where I'm kind of, I don't want to say making it up, but, kind of synthesizing what I'm gleaning from, the limited authority out there on this, and to fashion a common sense roadmap for.
So that's
these
part of
lawyers.
the inherent tension, is that even when you talk about the factors and put them up front, you've got a fundamentally different rule for people who work as an employee for their client, because it includes all these factors that don't adhere when you're not in that relationship.
Right. So so these factors don't apply if you're at a law firm, right? Like, we're not even, you would not do this analysis to determine whether 1.8.1 applies if you're a lawyer who works for a law firm and is hired by a company. Because you wouldn't, because there's a presumption, the facts are, the presumption is that you're being presented with a employment agreement. So it doesn't apply to a fee agreement, right?
Right.
Yeah,
It doesn't
maybe
apply
that needs to be.
it doesn't apply to the initial fee agreement, and then there's some difference of opinion on whether it would apply to a modification of a fee agreement, right?
Right.
So.
Yeah, I know. So that's kind of, I mean, and that's, right. Well, generally, whether or not 1.8.1 applies to a modification. Yeah. I'm just trying to think then, going back and looking at the factors. Another type, well, an employment agreement, a stock option agreement. I mean, in-house lawyers can be hired as officers, right? It's not necessarily even an employment agreement.
Mhm.
And typically they are officers, and they can have, they can also be the CFO, so they can have dual roles, which we're not going into. Okay, so is there anything else on that? I mean, I think maybe, I'll rework that section, but I'm not gonna change it fundamentally. I think I think that the basic approach is correct, and that maybe it just needs to be, like, for example, fleshing out the factors or putting it up more up front might be a better way to provide more guidance. Anything else? And then, yeah. Oh, I'm sorry, I didn't see hands.
Yeah,
Go ahead,
apologies
Joel.
for not having read this. We just came back from Hawaii and my mind was still there. I didn't read everything. Okay. But did you take a look at the General Dynamics case for guidance on this?
Yeah, it's cited in here somewhere.
Oh, okay.
Anyway.
Okay, because that's what came to mind.
That's the general, yeah. I mean, so the General Dynamics case talks about, and forgive me, I haven't read it. It talks about the employee-employer relationship question, and yeah, it's like the difference. That there is California case law generally that does recognize that distinction, that there's an attorney-client relationship and there's an employee-employer relationship, and a lawyer can fulfill both roles. So I do, yes, I do go into that. It's just then, what does that mean when you take stock, and your employer? Yeah. And then Eleanor, did you have a question?
I was going to the same case in the same area. Like, I think there are a few cases, especially dealing with like lawyers, whistleblower, etc., that kind of delve into the rights of a lawyer to bring claims as an employer versus as a lawyer, and those types.
Yeah. Yeah, so there's like the employment discrimination cases, and then there's the privilege cases that I forget is that the general, anyway, yeah. So there's so we're pretty clear that there is that the California does clearly recognize that distinction, it's just that, again, what does it mean in this particular context? Okay, and then the last part, just so we can shorten this up, I think we're gonna just take out issue 3 altogether about conflicts when the lawyer is asked to advise the acquisition scenario. So I think we'll take out those facts. Oh no, wait. Does the Yeah, I mean, I think we can keep the facts in there about the merger or acquisition, just to illustrate that as, even if, just to illustrate the ongoing application of Rule 1.7 in after, the employment commences. So that you still have ongoing duties to assess whether or not there is a conflict, arising from the lawyer's ownership of stock. And so that would materialize, most starkly when there is a merger or an acquisition where the lawyer is, set to benefit greatly, maybe, and so that's where I think that a 1.7 conflict waiver may come into play. But I don't think we need to go into the conflict issues when the lawyer's asked to advise individual shareholders on their personal interests. I think it's just unnecessary. So that's it.
So I have one little observation. we say at the outset that the legal department at the new company is only like 3 lawyers. And that raises some concerns to me when we talk about screening, whether that's realistic. And that might be worth mentioning that, or increasing the size of the legal department in our hypo or whatever, you know, just because a 3-person office with a screen it sounds pretty vulnerable to me.
Yeah, I mean, I think so. We're talking about like the 1.10.
Yeah. Some mention of the fact that, you know, it might not be applicable or successful or effective with 3 people. That would have to be assessed.
Okay. Where do I have that? Yeah, maybe, and it's also, it might be more clear to just increase, to make it not seem so much like it's a startup, so that the 1.8.1 analysis is easier.
Right.
Yeah.
Right.
So
yeah,
I'll
that's
make,
actually a good point. Yeah.
yeah, so I'll maybe change the facts to make it a bigger legal department or more established company, I guess. I'll figure it out.
Do you need any more guidance from us? I mean, it sounds like you have a plan for the next pass.
Yeah, when is our next meeting? It's January 12th.
Yeah.
Right. Yeah. No, I think
Our working group, is there anybody else or just us?
it's just, yeah, me and Dan.
We
Somebody
need
else
some more
want
people
in?
on your working group.
Yeah.
I mean, I think Raquel might have been on it, but I, you know, frankly, I wanted somebody to just take another pass at it, like Dan did. I'm bad at scheduling meetings for the working group. I'm very sorry. I know that's no excuse, but I haven't been able to really get into that rhythm.
What if I join the working group and my main contribution will be scheduling of meetings?
I would love that.
Okay.
I feel like I need to be babysat, but yeah,
no, this is
helpful.
Look, this is an overwhelming opinion just because of this. It's a pretty vast landscape covered.
I'm just having trouble like staying interested in it since it's been sitting around for a while and getting it over the finish line. So I do.
Wait, do we have to be interested in these things too?
Oh, no, that's not required. It'll get much more interesting once the public comments come in.
Yeah, right. Yeah, I want to get it to that point. I really do, because I'm curious to see what people are going to say.
Right. Okay.
They're gonna hate it. They're gonna hate it. I guarantee it.
I hope so. I want some emotion about it.
Yeah, someone to notice it, right?
Yeah.
Okay.
Okay, that would be helpful. And then
anyone else have any thoughts on this opinion today? Well, okay. So let me look at my little schedule here. Thank you, Cassidy and Dan, for all this work. I appreciate it. I think it's getting closer.
Yeah.
We are going to move now to a planning session. And I'm going to try to find on my desk here somewhere my notes for this planning session. Erica, do you have your materials handy?
I do. Yeah. So
were we going to talk about planning first and then potential opinions, or vice versa? Or
I think we were going to talk about in a little bit more detail the sub-entity review process that's going to occur in 2024. Yes. Because I just want to give you guys that context when we start talking about planning for CoPrac for 2024.
Perfect.
And then I think after that, it makes the most sense to address the new opinion topics, because we don't want to decide we want to take on a million topics if we decide something different as it relates to planning.
Right.
So I can talk about the sub-entity review process, Brandon, if you'd like first.
Please, because okay. I will get it all wrong.
No problem. So this is something that is frankly years in the making. So in 2017, the State Bar had a governance in the public interest task force. And what came out of the recommendations of that were some changes to committees. including to this committee. That's when, at least I believe, that's when COPRAC shrunk from a 16-member committee to a 12-member committee. And then it went back up by 1 member to have an advisor who is typically the former chair, so that there's a little bit more of a succession plan for COPRAC, like we kind of talked about this morning for attorneys. So as part of that as well, what was decided was that there should be a sub-entity review of every state bar board sub-entity every 5 years. So it has been actually a little bit over 5 years, and so it's time for that process to commence. COPRAC is not the only committee subject to sub-entity review for 2024. I believe there are 7 of them. And this is being handled by the leads on this project are 2 Board of Trustees members and a few members of the executive director's office. So what this is going to look like is essentially a 3-part process. The first is kind of a threshold question, is to determine the necessity of the sub-entity and whether the sub-entity's purpose is aligned with the state bar's mission, which is primarily public protection. So, you know, I would certainly make the argument that advisory ethics opinions that promote compliance with professional responsibility obligations meets that threshold question. I think we will still, you know, go through that analysis, but where I think we're going to spend a lot of time in the sub-entity review is part 2 of that assessment, which is like operations of the committee. How does the committee, is the committee effective? Is it transparent? And how is it accountable? And so I think that's where a lot of the work is going to occur. And what that work looks like is our executive director's office staff may reach out to you to ask you questions as it relates to the committee's effectiveness, transparency and accountability, among other things, and see what you think. And it could also be that they reach out to former COPRAC members, former COPRAC leadership and others. And this is in the initial formation process. So this is all subject to change, but it's kind of my understanding of this process right now. And then part 3 is a recommendation and report. And what that may look like is, you know, changes that are recommended to improve those things, the efficiency, transparency, and accountability, you know, potentially restructuring changes. You know, does COPRAC need more members? Does it need less members? Does it need different purpose? And so those are things that I think they would be looking at. And then COPRAC has rules that exist that you have maybe seen a few times. They're housed on the State Bar's website. They're not formal rules. They are kind of pieced together rules based on numerous board resolutions that have shaped COPRAC. And so I think a part of the sub-entity review will be looking at those as well, including considerations as to whether some restrictions, such as you know, exploring unauthorized practice of law issues, should continue to exist. And right now, the rules prohibit COPRAC from opining on pending legal issues. You know, because COPRAC addresses issues that relate to professional responsibility, arguably they always relate to pending legal issues. They're just not necessarily given to us in that format. They're usually given as hypotheticals, or they're self-generated by the committee. So I think those are things that will be explored as well. So all of this to say that I hope that as part of the planning discussion you guys are about to go into, you do spend some time talking about like effectiveness and efficiency and goals for 2024. But whatever is decided today will, I think, be informed by the sub-entity review to some extent. And I also think that that sub-entity review will be informed by whatever is decided as part of the planning conversation. So I can answer any questions you have on this to the extent I have information about it. Just a reminder that this is still in the planning stages, so subject to change.
It reminds me of that scene in the movie Office Space where they make each employee justify their existence at the company. You know, I mean, we all volunteered for COPRAC because we think it has value. So I don't think there's a lot of dissent within the committee as to the continued existence of COPRAC being valuable, but we hope the bar agrees. So I don't have any questions. Not because I'm not interested, but because I don't think I fully grasp what role we play in this review enough to formulate intelligent questions. But I open the floor to anyone who has any questions about the sub-entity review.
I think
I see.
Topeka has her hand up.
Oh, okay, yes.
Do we know when in 2024 this process is going to start?
I think sooner rather than later would be my guess. I do not have an exact date. The board typically has a planning session that occurs at their first meeting in 2024, which I believe is the, let's see, the 19th and 20th. What dates are those? 18th and 19th, excuse me, in 2024. So that's the board's planning meeting. So I would assume it's going to start around that time, maybe slightly thereafter that time. But there's I think it could be like up to a year-long project. I don't think it's necessarily going to be a very, like, we do this in 1 month. And so I think the committee itself will have a lot of opportunity to weigh in on this as well.
And then who actually does the review again?
My understanding is that it's going to be done by 2 members of the Board of Trustees, as well as in conjunction with some of the staff of the Executive Director's office.
Okay. Got it. Well, I appreciate the heads up that that's coming. I tend to think that we are already, everything we're doing is with an eye towards public protection. I don't think there would be any other objective, even if we wanted a different one. I'm not really sure how we would spin that way, but that's my 2 cents. So let's talk a little bit, if you think it dovetails well, Erica, about efficiency for the committee, because they're going to be looking at that.
Brandon?
Yes, Joel.
Yeah. It seems that whenever I put my hand up, I freeze on this thing. So,
Well, that's not a great correlation.
I don't know. It is a correlation. I've discovered that, but I apologize. And if this is out of order, Erica, let me know. But that process that started in 2017 led to a discussion about the utility of the mandatory fee arbitration committee. And the argument there was made that certainly providing a ready vehicle to solve disputes between attorneys and clients about fees, and advising attorneys about how to avoid those disputes and all the things was the argument meant was something definitely was within line with the mission of the bar. The decision, however, was to fold up the committee and put that on COPRAC. And with no disrespect, I just think the structure, not only, reducing COPRAC in number and eliminating the mandatory fee arbitration committee just has not covered that base, but considering that mandatory fee arbitration is a statutorily required event in the life of every attorney. So would it be out of line to also include in this review of what COPRAC is doing and what its mandate is, a revisiting of that decision? I don't think it was a wise one. And, I think we lost, we had 16 members of the mandatory fee arbitration, many of whom came onto the committee with 10 to 20 years of experience doing mandatory fee arbitrations. And in my case, served 40 years total on the program and on the committee. But I think we've lost that. And particularly because, as talented as some of our members are, only a few of us have that deep background in the problems that have arisen in fee arbitration matters. So how well COPRAC is covering that base, I think, would be a fair topic to raise for reconsideration at this point, after seeing the results of 5 years without it. So if there's some way that we can get that on that agenda, or I might be heard in some way to urge that on the agenda, I sure appreciate it.
Joel, I appreciate your comment. I don't think, I don't think it's been a great public service to shrink COPRAC and handed all the responsibilities of the MFA committee, we have not prioritized the MFA work on COPRAC. It's not the fundamental focus of what we do on this committee. And as a consequence, it's not getting the attention it used to get. We are much more focused on ethics opinions rather than arbitration advisories. So if anyone asks us, Joel, I'll be sharing my point of view as well. And I guess they made COPRAC smaller for some reason that maybe they'll tell us too, because it's a volunteer committee, so I don't really know how, if there are capable members of the public who will serve for free, how it advances the public protection goals to be smaller as a committee. But you know, maybe they'll consider some of that. But yes, Erica.
I'll just add to that. I think all of these things are appropriate things to raise as part of this sub-entity review. I don't think there's anything you can or can't raise, especially if you're personally interviewed for this. I'll just say, related to the membership, the size, composition of the committee, one thing that I intend to raise is, now that COPRAC's being asked to look into kind of not specialty areas, but intersections of professional responsibility obligations with other things, AI being one of them. You know, there was a large benefit, at least to my mind, of having non-committee members serve as kind of subject matter experts, with Nima and Daza, for example, coming in to work on the AI topic. If there are other topics that need to be explored that do require some specialized knowledge, I think that was kind of unprecedented for COPRAC to have them come in the way that they did, at least to my knowledge, and to have the ability for that to occur going forward. And if it needs to be, you know, formalized in some capacity, that's certainly something that I think the committee may want to explore as well. So all this to say, I don't think anything's off the table as far as considering ideas that fit within kind of the overall rubric of exploring how COPRAC operates. I
actually totally agree. I think that's a really, really useful process. It was very helpful for us. And, you know, it goes beyond our horizons, which is really good. So one of the things that I wanted to try to do for the benefit of the members of the committee and for the benefit of the committee is, and I'm not sure how to do this, so I welcome all input, is I'd like to be able to narrow, like we did for this meeting. There were just 3 drafts opinions to review. Some, you know, I know that those of us that have been on the committee for a while have had in years past, you know, many, there's a huge volume of materials you get before the meeting. And, but only a fraction of it will actually be discussed in depth. And I think that doesn't serve the quality of the discussion, right? I'd much rather us be really clear on what we're going to look at. And so that everybody has time to really dive in deeply into the material. I think we're going to get better contributions from everybody, and it's to the good for everyone. So, you know, one of my goals is going to be to try to, with plenty of notice for a meeting, have the materials to everybody and keep it pretty focused, you know, and not, but there's a couple ways you can do that. You know, you can check in, I can check in with all the working groups 2 weeks before the meeting and say, who's got something ready? Or we can make assignments at a meeting a month in advance. You know, we can say, we're going to need a draft of this, new updated draft of this opinion by the next meeting. Fully cognizant that there's no teeth to anything because it's a volunteer committee and we all have our own caseloads and things. And that could leave us, you know, high and dry at a meeting without materials to discuss. So, I mean, what we did for this meeting worked very well because people had stuff prepared, and we can continue with that. But I welcome people's thoughts on whether, you know, receiving the materials a week in advance is enough time. Is this about the right amount of materials that you can read, you know, with real engagement and be prepared to discuss? I just want to get people's thoughts on that because I want to maximize sort of like the quality of our interactions.
Brandon?
Yes.
My view, and this is personal for me, is that the threat of public embarrassment is a great motivator of action. And I would like to see us assign specific projects to specific people with specific dates
Mhm.
and hold it to them. And under threat of public embarrassment if you don't make those.
In the discretion of the chair as to what the embarrassment is. So that sounds perfect.
So just to call
Um,
them out and say, you fool.
Yeah, I'm gonna use the Socratic method. It's gonna be great. No, I'm with you. I like that idea. It is tough in a volunteer context and with uncontrollable caseloads sometimes. But I do want to encourage people to dive in and do work. So I take your point very, very much, Joel.
Well, I also think like even if you're not easily embarrassed, as I am not, it helps. This is a deadline driven crowd, right? So even if it isn't going to embarrass you, it helps to have a specific deadline, because then it just goes on the deadlines and we all have many of them and we meet them, right?
Right.
I agree, because I'm the worst violator so far. So in terms of getting an opinion out, so I welcome the shame, because I'd much rather be scheduled and I can put on my calendar and get it done. Because otherwise, if it's not on my calendar, I'm not scheduled. I've got something else I have to do, and then next thing I know, Angela's saying, "Hey, do you have anything for the meeting?" Like, oh crap, yeah. So I'm all for scheduling opinions for like next meetings.
So maybe what I should do in this instance, and we can see how it goes over time, is like literally within 1 week of this meeting, I've contacted all opinions in progress and sort of said, we need your draft a week before the meeting, or we're going to do yours in February, and just start doing stuff like that. I don't like telling people what to do, but when they ask me to, I can oblige. Yes, and I'm also intend to go through, and we can do this when we talk about new topics or something. I want to make sure some people are doing a lot of work on working groups that have atrophied over time. So they're just all alone working, and that's not fair and fun. And maybe we'll dragoon some people into working groups that didn't even want to be in the working group. Great way to make new friends. Okay. So that's my goals. I mean, there are other, that's all opinion focused, right? There are other things COPRAC could be doing. We could be doing more CLE. I don't think we do any CLE except for our seminar, right? Like formally as COPRAC. Does that appeal to anyone? I do plenty of CLE. I'm sure most people do on my own or just through other invitations. I'm not looking to add more of that to my life personally, but do we think that's an important role for COPRAC to be, is there a need that's not being met in terms of ethics CLE that we are suited to? Just looking at like, what benefits can we offer the world as COPRAC?
I just wanted to point out, Brandon, that we do frequently get requests for speakers from different bar association groups.
Yes.
And I think we've been pretty responsive to those requests and tried to get volunteers when we get them. So I think, that's a good way of addressing it, rather than, I mean, if people are interested in proactively putting on CLEs, I support that. But I do think it might be difficult given that we're already, facing a lot of time constraints in just getting the opinions timely process. So that would be my suggestion, that it seems like people feel already comfortable in reaching out to ask for volunteers when they need someone.
I think I couldn't agree more. So Erica and then Joel.
Oh, I'll just add, so yeah, we have already been, to pick up on what Sarah said, we have been reaching out to the leadership committee, and then I think we filter it kind of down or send it to everyone asking for speakers for specific MCLE. Our office at the State Bar is also doing a lot more of MCLE. I don't know if any of you have attended or seen it or are sick of seeing it, but so for example, we did one last year on CTAP, the Client Trust Account Protection Program. That's now been handed over to the Division of Regulation, but we're working on that with them behind the scenes a little bit. We've been on quite a Rule 8.3 roadshow. Bill's been on part of that roadshow with our office as well. And so to the extent, I'll just say, if anyone is like passionate about a particular topic that this committee has dealt with or otherwise, our office has our own like education development team at this point. There's been changes to the rules of professional conduct and to the MCLE rules. So MCLE, you know, there's now a civility requirement for California licensees to take starting in 2020, compliance period ending in January 31st, 2025. Tech as well. So as part of the AI recommendations, there was a requirement that our office include an MCLE program on generative AI. So we can kind of just meaning our staff can make you aware of these types of things that we're working on if you want to assist in that capacity as well. So just, you know, more opportunities to volunteer, which I'm sure you're all really excited about.
Joel?
Yeah, Brandon, back in the day before they cleaved off the trade association portion of the state bar, at the annual meeting, COPRAC was always putting on 1 or 2 programs. That sort of got supplanted with our annual ethics symposium, because I think that is where we're full up on topics, but we're not. I mean, we're pretty well covering the base. If that plus the in-house efforts of the state bar itself now, and calling upon us when there's a request for speaker on occasion here and there, pretty well covers the base at this point. So I don't know that we need to do much more in terms of offering ourselves up after distraction from our core work here for those kinds of additional programs.
I mean, look, that's my sense too, and that's the way we've been doing it. And if anybody wishes to be more proactive about COPRAC CLE overtures, that's absolutely great, and I'm all ears. But otherwise, I don't think we need to change this particular responsive model, right? I just wanted to put that out there for discussion. Another one is, you know, sort of writing updates or ethics alerts, or, you know, whether quarterly or biannual, or, and as we had talked about when we were talking about the illegal contract provision, you know, maybe it's worthy of a short article to be posted on the state bar. I don't know, again, I like that our focus is these well-considered ethics opinions and the occasional mandate from the Board of Trustees to look at something else quickly. That seems like a pretty full plate to me. But if anybody wishes to write these sorts of updates, I would suggest that anyone can do that, submit it to COPRAC leadership, you know, sort of just as like a editorial committee, and that can be done anytime. Joel?
Even when I raise my hand, it freezes.
Yes. Amazing.
Weird.
How is that possible? I do not understand.
I don't know. But anyway, I exist. I'm not frozen. Anyway, you know.
So you say. So you say.
Before I was reappointed to COPRAC, I talked to Dave Parker, and he told me about how exciting it was. They were planning, COPRAC was going to come out with these quarterly ethics bites, newsletters, or something like that. And when I was actually reappointed to COPRAC now 3.5 years ago, whatever it was, I was surprised to find that nobody was doing that. Does anybody know why that went away?
Or whether it ever came about in the first place?
Yeah.
I can address that to some extent. So I think there's a couple different things. So there was the ethics hotliner that Cassie referred to as part of the illegal contracts opinion. That is, it used to exist as part of the Cal Bar Journal, I believe. Like that was where it was technically published. The Cal Bar Journal no longer exists. That kind of disappeared when the state bar was deunified between the sections and the regulatory function. So that was done at times by staff in my office and Office of Professional Competence. Can't talk. And as well as COPRAC, or sometimes jointly. And then there was also a lot of self-study articles that were written by COPRAC, and including some recently by former member David Carr that never was published. related to client trust accounting that has now become a little bit, the article unfortunately is pretty dated because of all the changes that happened to CTAP. So what happened is when CalBar Journal went away, there used to be self-study articles as well as part of CalBar Journal. And there was a self-study test that individuals took, and then they submitted a paper check to the state bar to receive self-study. As part of, other updates to the state bar website, that function disappeared, and our office is in the process of trying to reinstitute that. I think to the extent this committee, wants to and has the bandwidth to, adding self-study articles could be of value for this committee to address, very succinct or relatively succinct issues that or issues that are of common discipline or complaint. Communication is always one of those. And so that is another way. But as far as the reason those went away is mainly related to where we could house them on the state bar website. But those issues have been resolved. We just now don't have any current content currently to post.
Okay.
I'm wondering if there was any pushback on those kind of informal communications, that we shouldn't be using the imprimatur of COPRAC without it being a vetted opinion that goes out for public comment and all that. If that was sort of a chilling effect, it might not be worth the effort. But on the other hand, if that would be welcome, then it might be worth the effort. Yeah.
I don't think it's unwelcome, I'll say. I think that, especially with like the practical guidance that was done on the AI issue, I think it certainly needs to be decided what things make more sense as opinions that are subject to the public comment process, as opposed to, articles that maybe don't have as much criticism before they are posted being done. But I don't think at least my knowledge, at least within the state bar's leadership team, is that there's no issue with COPRAC doing those types of things, as long as it's clear that they are not considered to be the same as formal opinions, which frankly are advisory anyway, but they're just certainly relied upon by others.
Cassidy?
Yeah, I mean, along those same lines, I think as far as like the hotline or the ethics alert situation, I think it might be appropriate to do it in just like we talked with the legal contracts, like maybe whatever the issue is not appropriate. Are we deciding that we're not going to issue a formal opinion, but it's certainly worth an alert. And the last hotliner I remember looking at, and we may have discussed this before, was the one in 2009 about the modification of fee agreements in mid representation, where the alert says it was considered for an opinion and was ultimately decided not to be issued, but we decided that it should be that these are the, I can't remember, but it was a 1.8 issue, right? So modification of a fee agreement, and that lawyers should really strongly, they were urged to comply with the rule with modifications, and that was because of the financial downturn. I remember, if I remember correctly, that
there was like a history with that one, and I might get totally wrong, but like COPRAC decided that rule 3300,
right, or 310 or something,
applied to midstream modifications of a fee agreement, but was it the board did not adopt it, or it was not, or it was pulled before it went to the board? Something unusual happened with it before any of us were here.
Right. So we could, it's not like we need to formalize that process, or maybe that was just a one-off, but I just like the idea of, when we're grappling with an issue and we think, it may not be ready, or I don't know if we want to have standard quarterly alerts, or if it's something that, it's a step below an opinion that we want to put out there,
right. And I'll be very honest, like the Los Angeles County Bar Association Ethics Committee has monthly updates and does all these things. They have like 36 members, right? So there's they're spreading around a workload really differently than we are.
And BASF is pretty good about getting alerts out in ethics corner stuff, and they're like 500 words, and
right.
it's not a big, heavy lift.
Right. So, if we were to talk about, I'm a little bit averse to talking about like numerical metrics for how productive an ethics committee is. But, it's certainly reasonable in my mind that we want to put out 2 or more opinions a year. That seems reasonable to me. I don't know. Of course, it doesn't matter how many you put out if they're not good, right? So that the number doesn't matter that much, but I think we're going to be asked some metrics questions to explain why we should exist.
Well, we should have some opinions to go out next year. We've got like 3 in the
Yes,
hopper, really,
right,
or at
right.
least 2.
I don't think
that
it's a
will-
problem to hit that. And I do think it's a strange way to look at ethics opinions, right? They're not widgets. It's not a productivity measure, but I'm not sure. I'm not hearing a lot of desire to commit the committee to these quarterly ethics alerts or self-study articles. But I think we should all be fully receptive. Any member that wishes to prepare one of these things, it will have a home, it will have a use. But I'm not looking to foist that on anyone and obscure our focus on these ethics opinions.
Well, I think I think that we could get, I think if at most it should be quarterly. And I think I think a quarterly ethics alert is doable. That's only 4 a year.
Right.
And if they're like a page long,
They're
how
brief.
hard is that? Yeah. So I would vote for that. I think I would vote for that if we're
I
going to
like that
vote.
idea.
Okay. Who else is on board with that? Hey, this is pretty good. Okay. I mean, we have 1 year's worth of ethics alerts just with the people that raise their hands. I like it.
That was not a volunteer. That was
Oh, wait a minute. No, well, Erica, you had a point.
Well, yeah, so I'd like to, if people are in favor of that in concept, I think we should talk about what that might look like, just very high level. If it's a quarterly thing that is drafted in a drafting team format, or if an individual takes on that quarterly ethics alert, and then if so, if there's like some sort of vetting or just proofreading committee of some kind. So I think it'd be helpful to, Cassie, maybe Bassif does something or LACPA does something that
Well, yeah, we do. Bassif does. I don't know how often the ethics corners go out, but my firm, we do a tip of the month every month. And I use, sometimes when I have an ethics corner assignment, I use that. So I'm happy to do, to bring whatever tip of the month we do, I can at least use those as a basis. Sorry. Get out of the way. Use that as a launching pad. I mean, because so I'll have 12. We only need 4, so that's some material that I can, use to at least present a quarterly.
Yes. And we should give a little thought to as to how it is labeled, right? It's not, if the full committee never sees it before it goes out, it's not really like a COPRAC statement, but it's a statement by a member of COPRAC. I mean, how would we say that appropriately? Because I know that none of us can ever say we're talking on behalf of COPRAC, right?
Well, we can, I don't know, timing wise, but we can, set aside like a half hour or so for one meet, the meeting before the quarterly goes out to say, here's, here it is, like as far, it should be drafted and vetted and then say, great, because what I'm thinking is just a page.
Right.
Something, and we can try it again. Like there's always some issue that that's topical at least 4 times a year,
Yes.
that we could probably address. So I think that's doable, and I'm happy to provide the material, and we just need to figure out the timing as far as it being reviewed by COPRAC, and then we'll have the COPRAC stamp of approval when it comes out.
Great idea. And I think we saw enough raised hands that this is like a go, right? We should just incorporate this into what we're doing. Okay. Well, that's a couple things.
Getting back to the issue of metrics.
Yes.
You look at the way COPRAC has worked in the past, sometimes an opinion will split into 3 opinions, and we're more prolific. other times, like these past, I think just this year, we've spent a total of 2 meetings worth sidetracked with AI.
Yeah.
And so, that has to be kept in mind when somebody says COPREC really ought to be putting out 2 or 3 or whatever number a year. It really, you shouldn't schedule it that way.
Right. I agree. I agree completely.
Or who knows when a Girardi situation is going to come up. It's what the demand is, not what the metric for an output is.
Right.
Yeah, I mean, since I've been on the committee, there's been 3, as far as like, or maybe even 4 major topics that had nothing to do with ethics opinions, AI and CTAP and paraprofessional.
And 8.3, well, I mean, but
8.3,
is
that's
ethics
5.
related, but
Civility. I mean,
Yeah.
I mean, I know that there's always some kind of topic, but that they, if we went back and look at each meeting from the last year, I mean, Joel's right. There were at least 2 that just took up those topics alone,
Yeah.
So I think we shouldn't beat ourselves up too much about being productive on ethics opinions.
Well, excellent. Okay, so I'm pretty comfortable with this. I think we should move to potential topic ideas.
Can I ask another sort of a
Absolutely.
metrics related question? But is there a guideline or any kind of like style manual for how long the opinions should be? I get the sense that they're getting much longer than they used to be, and that obviously takes longer. And Cassidy and I dealt with this a bit in this, where the in-house counsel opinion, where we both, I think, felt like it's creeping because there's many more questions that come. But if we had some hard deadlines, like to say 8 to 10 pages max, should be enough to say pretty much anything about anything, or do a different opinion.
Or split it up into opinions or whatever.
Right.
Yeah.
I'm not aware of any such limitation, and I know that it has changed with the style of the members, right? We've had more professorial members. We've had more
like myself.
Exactly.
Well, a related topic came up recently when we discussed the protocol or the style for including hypotheticals in that. Or if we include hypotheticals, how to put them in. Do we bunch them up? Do we split them up? All that kind of stuff. So
what I thought was really funny is that
I would do away with hypotheticals entirely if it was and that was
I don't know. I love hypotheticals.
Right. See, that's just it. And then in one draft I did this thing where I put the hypotheticals at the end, so that like I did all the analysis and background, hypos at the end, and analysis of each right there, so you didn't have to go back and forth, which I thought was like, what a gift to the readers. And there were literally public comments talking about how I had deviated from the proper way to do it. So I don't know. I'm not aware. Erica, maybe you and I can look into whatever style guide there is, if any. I think it's just us.
Yeah. Sarah, Raquel, and I don't know if you all recall, we were working on this and it got stalled, frankly, based on like my workload issues. I don't know, probably about Sarah and Raquel's as well. But so I think this is still a work in progress. I think this could be something that's valuable to come out in the sub-entity review too, personally, in some way. Not that we want, not that you all want like the page number dictated to you, but I think, it is helpful to some extent to know that they shouldn't be 30 pages. We cite them on the ethics hotline constantly. And I will say that it's much easier to use the older ones that were like 2 paragraphs, but also the issues are much simpler. So I think, the length comes with just the much more complicated nature. That in-house counsel one that Dan and Cassie are working on is certainly a prime example of that. But you could split it, right? So, this opinion focuses on this particular issue related to, salary for an in-house counsel, and then do others as well.
Yeah, I'd say idea is not that it is totally driven by the page numbers, but that gives you a sense of the scope, right? And when you get those standing orders from a court, you make it work, right?
Yeah,
right.
And it's better.
Right.
Yeah.
Well, you put it all in your declaration.
That's right. That's right. Supplemental declaration.
Right. Well, okay, I think this has been quite productive. Erica, am I missing anything, or should we move to new topic or topic ideas here?
Deepika Deepika has her hand raised, but
Oh,
otherwise.
I'm so sorry, man. Listen, I have a standing apology for this, Deepika.
No, no problem at all. I was just wondering, going back quickly to our conversation about metrics, do we have a general sense of how many requests for an opinion we get in a given year? I'm sure it probably fluctuates, but I was wondering how many of those types of requests we tend to get.
I'll just say it really depends, and you'd have to categorize them in the sense that, as they were just talking about, the special projects have come directly from the Board of Trustees. I would count that as a request. And then there are internally generated requests. We're going to go over one of those that I've come up with, hopefully in this conversation. And then, you know, we'll talk about ABA Model Rule 1.16 changes. And so that's, I guess that's self-generated or ABA generated. And then as far as true publicly generated, in recent years, it doesn't seem like there's been too many, you know, like 4 or 5 a year about. I think, but we could certainly calculate that for you, but it's not a ton. And I think that, again, I keep going back to this, but as part of this FNG review as well, a big question is, where do the topics, where should they come from, and where do they come from? And should they come like from the general public? Should they come from the Board of Trustees? Should they come from COPRAC itself, or continue to have a combination thereof?
And Deepika, it is, I'll just note that some of the genuine requests we get are like so specifically like, let me tell you my legal problem with all the facts and what do you think, you know? So some of them are just not appropriate in that sense.
And issue an opinion that solves it too.
Right. I'm in a case right now where I could really use an ethics opinion that you could write right now that says X, you know. But not all of them are like that. Not all of them are like that. All right. Any other thoughts about our sort of work plan? Any of this? Okay. So we should move to topics. And Erica, do you have any suggestions for how to start on this topic here?
No, I think, Ange, if you want to share the attachment that was provided, at least the beginning of the attachment that was provided for the new opinion topics. I do think we should at least talk about the 1.161, as that came from the ABA to the Chief Justice of the California Supreme Court, as it likely, I would assume, went to every Chief Justice of every jurisdiction. But it was then forwarded to this committee to discuss. So as you'll see on this document that's showing on your screen, there was the issue, and any attachments that were associated with that were at the very end of that document, which was what made it so voluminous. So if you haven't had a chance to delve into it, we certainly can later, but I think at least discussing 1.16, and then we could go in maybe sequential order, but I think that's the one that is most important to talk about.
I think that's a good idea. Erica, are you up for talking a little bit about the changes that the ABA made to their model rule 1.16, which I'll note at the outset is different from our rule 1.16, such that we have to think about whether these changes really impact our rules?
I can talk very high level on it. So the changes that were made to it, and if anyone knows this better than me, I would welcome you to chime in. But those changes were essentially to require more due diligence as it relates to vetting of clients, to essentially allow for, I would argue, to make it clear that you can't assist a client in like money laundering as a large example, but it wasn't explicit to and limited to money laundering. And then, as the ABA has indicated, it was implicit already in the rules. They just made it explicit with changes to paragraph A of 1.16. And it says that you have to inquire into and assess the facts and circumstances of a representation to assure that you will not be facilitating a client's fraud or crime. And then it talks about what you must do if a client wants to use or persists to use the lawyer's services to commit further crime or fraud, including discussing the limitation of the lawyer services and then eventually leading to withdrawal. I'll just say that because our 1.16 is different and because we have a standalone 1.2.1 that is different than 1.2 in other jurisdictions, I think it's worth the committee discussing this, but I do think there are notable differences that the committee should look at as well before considering just a blanket adoption of the ABA model rule.
Right. And I'll just note that the real difference that I didn't see present in our rules is sort of this continuing obligation in the ABA model rule to assess, kind of be sniffing out for you know, they talk about, it's mostly money laundering, but drug trafficking, human trafficking, these other things. And they give a list of sort of red flags that should make a lawyer really take a look at whether that lawyer's services are being used to assist something nefarious. And we have rule 1.2.1. I'm not sure how clear in our rule 1.2.1 a continuing duty to assess is. We have like know or reasonably should know. And I'm not quite sure how that squares or overlaps with a continuing duty to inquire and assess. I don't know. But that's one question. And the other question is, do we wish to, if there's some daylight between the two, what do we want to go farther and with what the ABA has?
I'll just add that because of the formal nature of this request, it may make sense for there to be some sort of document that indicates why COPRAC decided not to opine or not to adopt some version of these amendments. If that's well, one way or another, I think there should be some sort of formal document that explains COPRAC's decision on this. And so, you know, certainly our staff can assist in that drafting, but I think that it may make sense for a drafting team to, or a working group of some kind to exist to kind of go through these issues so that they can be presented to the full committee at a future meeting.
So I think that's a very good idea. And we should seek volunteers right now for a working group. Because this is a pretty limited project. This is probably I mean, obviously, if we decide that, oh, yes, we want to suggest a revision to Rule 1.16, it's not a limited project, it's a large project. But but the initial research into this and presentation to the committee of suggestions or recommendations is not a huge task. So I would solicit volunteers and perhaps volunteers that are not overly committed on other drafting groups already. All right, Topeka and Bill. And am I missing anyone else? Because I can't see everybody.
Sarah, I can help out as well.
Okay. Well, thank you, Sarah. Thank you all. I think that's really useful. And I think the goal should be sort of a brief bit of explanation and recommendation to the committee at our next meeting, you know? And if the recommendation is yes to pursue a revision, I'm in no way suggesting you guys should have that all together, you know, substantively by the next meeting, but just let us know what your sense of this is after looking into it. I think that'd be extremely helpful.
Okay.
Staff can send just the relevant material, so it's just one combined document to this working group. So we'll work on that so you have that ready to go.
So we should probably go back to our top of our list of potential opinions, right? See who's interested. So the top of the list there, opinion number 2, is a very fascinating and highly charged topic, right? That and this came from this was a request, correct? Is that
Yes, that is correct. And I can add a little bit more to this. So there's a few things. So since 8.3 was adopted, this actually I think came before oh yeah, I can just tell based on the timing of the request. Yes, this came in before 8.3 was adopted. So there's an 8.3 component to this that has arguably been addressed by 8.3 C, which says that there's no duty to report a lawyer who has assisted someone in obtaining abortion care in a state where that would be a violation of law. So that's one aspect of this, is that it's arguably been resolved. The open question is, are the State Bar Act and the rules of professional conduct basically just say that you must comply with law. And I think that the clarifying issue here is whether or not that includes laws that exist in other jurisdictions that do not exist in California. Looking at that, and then also looking at it as it relates to like reciprocal discipline and those types of things, if you're licensed in multiple jurisdictions.
Very interesting. Because 8.3 C is the exception you're talking about, right, Erica?
Yeah, so that 8.3 C addresses the duty to report this type of conduct, but it doesn't address
whether it's independently disciplinable.
Correct.
Yeah. Well, so there's an inference that with the adoption of 8.3 with C in it, that it was the intent. I mean, it would seem absurd that you would get discipline. I don't know. I mean, there's a logic to it, but it may be worthy of clarification, or at least our opinion on the matter. I think that's a really interesting potential topic.
I believe this was discussed to some extent at the May meeting, as it indicates. What we also talked about, so as you'll see, we talked about amending or updating the marijuana opinion to address more of these types of topics, not just marijuana. So that's one avenue this could take. I will just say to whoever decides to take this on, it may be that the existing laws in California don't allow for the analysis that I think people might be leaning towards. And so I think that's certainly something that needs to be explored as well.
Can you elaborate on that a little bit? I mean, if the goal, if the consensus here was that, yes, this should be not subject to California attorney to state bar discipline, does the BNP code, it's more rigid than that?
I think the BNP code is the issue here, and I'd have to look at it again in more detail. I looked at this back in May, and I apologize that I'm not as fresh on it, but I believe that was the issue. It seemed like it was something that could be addressed within the rules of professional conduct, or guidance could be addressed vis-a-vis the rules of professional conduct, but that the State Bar Act made it more challenging.
So would it be appropriate for COPRAC to, if it were the consensus of the committee, to suggest guidance and suggest a revision to the BNP code? Or is that inappropriate?
Well, I think there's twofold here. So if there is not the availability of an opinion to be developed because of the Business and Professions Code, I think that's something that can be presented to the Board of Trustees as something that they may want to consider as a legislative priority.
Right. Okay.
I have another just follow-up question on that. Is it something that, I know this wouldn't necessarily be COPRAC doing this, but is it something that the state bar disciplinary, if they could just say they're going to forbear from enforcing violations, like could they announce a forbearance policy like other administrative agencies do sometimes?
I think that would be unprecedented. I don't know the answer to that. I think that would be unprecedented for our chief child counsel's office. That doesn't mean that they wouldn't or couldn't necessarily. I'm just not sure that has ever occurred before.
Okay.
Well, so I would suggest a working group to look into this issue with state bar staff a little bit, to look at the BNP code and give some consideration and maybe report back to the full committee. I would be happy to volunteer on this one. Does anyone else interested? I mean, that's okay. I'll just do it myself. It's fine.
join
Look,
you.
it is actually okay. I'll just work with Erica and staff and come back to the committee with some information to see if that piques anyone's interest.
Yeah, Brandon, I'm also interested. I just thought I might be spreading myself too
Yeah,
thin.
you've been very diligent in volunteering.
But I think that since there's a lot of members not here, maybe it makes sense
Yeah.
to email the group to get an additional volunteer too. 'Cause
Yes, great idea.
Eleanor, did you say your volume is faint on our end? Did you indicate?
Yeah, I'm not sure why that is. Can you hear me?
A bit, yes.
If you want assistance, I will help you. It's not on the top of my list, but I am looking for another one. So if
Okay.
no one else volunteers for this, I'm happy to do it.
Okay, sounds good. I'll send out the email, and if I don't get too many, a huge crowd, I'll reach back out. All right. I mean, we could go through these one at a time, but have members reviewed any of these and have any that grab you as interesting as potential opinions? Worthwhile?
There is one new one that came in since the last time. I think everyone has reviewed this. I can't. Do you have it, Ange? There you go. It's the 6. Oh, excuse me. There's 2. It looks like so 7 and 8. I believe are ones that the committee has not already discussed.
Oh, wow. Very specific.
Very specific. And on this one, I have, I think it's in the materials, but we did ask this individual if they thought it was addressed by the existing rules of professional conduct as far as disclosures. And they indicated that they wanted a standalone would be their request.
Standalone opinion or rule?
Let me see. Oh, I apologize. I'm talking about number 8.
Okay.
Can you scroll down so I can see the rest of 8? Yeah, there you go. So
Does number 7 feel like an attorney general opinion to anyone else as opposed to a COPRAC opinion?
It kind of does. I mean, yeah. And I agree about number 7, and I'm a little bit confused by number 8.
8 would be tough to pull off in California.
Yeah.
Yeah, there's a case of J&M Manufacturing that's basically what that question is right there. Then you're dealing with the fair reporting privilege and all kinds of stuff like that.
I'm just not clear on the context in which they're concerned about the attorney talking about a case publicly, because are they in an expert role? Are they not in an expert role?
I think of it like when you watch a financial program and they have to disclose whether they're invested in the stock they're talking about,
Yeah.
that's some type of thing.
Yeah.
And it wouldn't be possible.
Yeah.
Necessarily. I mean, you couldn't override confidentiality just because
Right.
they're on TV or whatever.
and you can't chill their right of free speech, right?
I don't think so.
Yeah. Yeah, I think that's talk about fraud.
Yeah, that would be tough.
is there still an interest in doing the AI one, given the guidance we just pushed out?
I'm not sure, and I can't tell if it's just because I'm fatigued from what we just went through, or whether, because it's very important, obviously, and do we think that the technology is mature enough that we can do like a formal opinion on that issue?
I mean, I think we just wrestled with that.
Yeah.
My view is if we're going to say anything, it would be in the vein of further guidance. And I'm not sure we're the right committee to be pushing out guidelines to developers. Like the way this is structured,
Yeah,
bothers me.
Brendan, I would let what we already put out cook for a while before we get back.
Yeah, I would too.
I mean, we were the first in the nation to address these issues, obviously.
We should be the second as well.
As Joel noted.
So just to make sure I'm clear on what I'm hearing, on topic 4, I'm hearing hold, as we normally call it, hold for further consideration, unless you want to decline thinking that it's better done by a different organization or entity of an organization. And then on 7, I didn't hear anyone who wanted to move forward with that one. And then similarly with 8.
I think that's right.
I think my vote would be to remove 4 altogether. I just don't think the way it's crafted is really our wheelhouse.
I agree with that.
Does anyone disagree?
No.
We know enough now to know what we don't know.
Yes. What were we considering on number 10 in terms of updates to the diminished capacity opinion?
I can take on that. So this is the one I generated, and it was brought to my attention by some members of the lawyer assistance program team. So there's 2 issues in there. One, which is the more minor one, is that it's not. We should be more vague in what the lawyer assistance program offers, frankly, in that opinion, only because that program is undergoing a lot of changes right now, and it says things that are no longer completely accurate about what the lawyer assistance program offers. The more important thing in my mind is that that opinion spends a lot of time talking about how there's no version of 8.3 in California. And that is no longer the case. And, if it was a 1990s, opinion, that may be just fine, but it's under the new rules and it's from 2021. So I think that general, members of the public and attorneys would look at that and perhaps be misguided. So that's something that, I think if this committee wants, staff could just make those updates and then present them to the committee for the full committee to look into at a future meeting.
I think that would be
Makes
really
sense.
helpful. Yeah.
Okay.
What, in that circumstance, do you do like an amended or something that supplants it? Obviously, it has to be somehow cited.
I think we're going to have to look into that, because it is a formal opinion and it goes through, they typically go through the public comment process and are approved by the Board of Trustees.
Yeah.
And it is a substantive modification, right? Even if it's
Right.
just a statement of existing law. So I'm going to reach out to our general counsel's office just to confirm the appropriate approach for that.
Okay. Are there any other instances where there's been like an amended opinion?
So arbitration advisories, we updated a bunch of them, and so the other, like when you go to the website and you look at the original opinion, it'll say updated and superseded by, and it'll just take you to the new one. But that didn't have to go to the Board of Trustees, right?
I don't
think the arbitration advisories, they didn't used to go to the Board of Trustees. They were just voted on by the committee. I don't actually know what the procedure is right now. But
let me try and find the answer for that. The arbitration, to Joel's point earlier, as far as getting those arbitration advisories out, that The most recent one predates my time in this office of the state bar. So let me see if I can find the information.
Is anyone interested in an advertising opinion, number 6? That's how I feel too. So there you go. Well, maybe another question is there anybody on the committee right now who feels underscheduled and would like to be part of more? You know, we can have people joining other working groups. I just want to make sure everybody is feeling included and useful.
I can help Sarah with the one she's working on with non-competes if she would like some assistance.
Great.
Based on what we decide to do with that.
We're not doing anything. My understanding is we weren't going to proceed with that, though.
I think that one's right. Yeah, that one's.
Yeah, that's what I said.
No, I'm sorry. Erica was going to first. The state bar staff was going to come up with the alternative. Maybe that's the one you're talking about, Makita. Sorry.
Yeah.
On the whether we want to pursue. That makes sense. Thank you.
Yeah.
The unenforceable angle.
On the advertising one, there was such a national effort to sort of simplify the advertising rules, and now I feel like the effort begins to try to occupy them with a lot of complexity. It's my opinion.
Arbitration advisories, since it came under COPRAC, have been approved by the Board of Trustees. So the updates
Okay.
have been subject to approval.
Okay. I personally view this as a pretty productive planning session. We've got stuff in the hopper. It's not the only planning session we're going to have. Any member who has a desire to propose an opinion, I welcome at any time. I think that's always great, but I think we have enough on our plate to keep us useful. Does anyone feel otherwise? Now, there's conflicts of interest because that's the end of the day, and we all know that by being quiet, we are speeding the adjournment, which is a lovely thing. Erica, do we have any more on our plate for today? No. All right. Listen, thank you all. This was a really productive meeting. I really appreciate everyone's efforts and input. I will do my very best in the next week to reach out to working groups and try to do that thing I said I was going to do, where we know what we're going to be working on at the next meeting well in advance, and I'll try to give out some reasonable deadlines to people. All right. Thank you all. Have a great Friday. Have a great weekend.
Thanks, Brandon. Have a great weekend, everyone.
Brandon.
Bye.